Pardon to make a mention,
Yes,
my
sir.
lord.
Yes.
My lord, this is of course the assignment of court number 12, but notice to be taken up before your lordship, my lord. My lord, this is a matter relating to selection of the GRS, my lord, where the my lord, qualification prescribed is 10+2. But my application has been rejected on the ground that I have not filed this graduation certificate.
When?
My lord, the selection process is now they are going to.
When it happened? Rejection happened.
My lord, it happened just, my lord, 15 days before.
Tell the date. When it
The date is of course not with me now. Lord, next week will be, they will be taking up the
telling the date.
date exactly, my lord, I have not brought, my lord.
Yeah.
Day after.
So, Lordship, earlier I mentioned 2022 meter mark.
You there.
Twice I mentioned.
You there. You there.
Lordship, phrase.
All 24, 24, 23, 24, 22. You. They will come.
Yeah.
Yes.
24. 22.
They won't not waste time.
Well, all identical.
The way you give it.
Yes, but despite the order of the London State Education Tribunal, which has been made conform to the Interim as well as apex court, now
When it was. What is that matter?
that matter to approve us.
Which year?
25.
Give it. It
Yes,
will come.
I mean, despite well, apex court order, they have rejected. I am challenging that order.
Phrase content matter.
Take that.
I mean, pardon, mention me, lord.
Next week. All fresh matters next week. Give. All fresh matters next week. They will come.
My lord, I pardon to mention,
Phrase matter.
All fresh matters. I will post them one day.
my lord, very urgent that the open part number 6, my lord. Carrying on construction, my lord, without any approval of the.
It will come next week. We will not halt the construction. Give next week.
Day after tomorrow.
They are holiday.
When the authorities of OSCP are demanding illegal money, and another is the non-payment of my pension, my lord.
My lord,
After notice, my lord.
My lord, the CDA is going to conduct lottery.
21.
my lord, one submission, my lord.
One second. One by. I will think again this. So yes.
My lord, illegal selection, my lord, honorable court direction.
Which year?
My lord, 2025. My lord, honorable court directly opposite party to immediate account and the emergency notice issued.
Pay first. You should tell them go on.
Very urgent matter, my lord.
My lord.
Yes.
25, my lord. Admission matter.
Give it.
Next week. For the fifth time, they have already filed the case.
Yeah.
Very urgent matter.
My lord, day after tomorrow, the lottery is going on by the CDA. By the CDA, the lottery is, they have declared day before tomorrow.
What is going on?
Lottery.
Lottery.
Allotment of plots in CDA.
I was wondering how lottery happened. Yes. Use them.
So it may come up in tomorrow, my lord. Very urgent matter.
When lottery?
Lottery will be conducted day after tomorrow, on 10th.
Tomorrow. 23.
Highly for restoration. Similar matter already disposed of my lord 4 cases. This is also similar.
Next.
This matter was resolved at
Lordship, petitioner is a junior teacher. He was terminated from his service without any notice.
When?
2024.
24. 2 weeks.
Two matter. In fact, it was disposed of rehabilitation matter. It was disposed of to consider the case in the light of Malayananda city case. Thereafter, the state preferred appeal. The appeal it was set aside on the ground that on the date of fresh admission it was disposed of. Thereafter, though ballot, the appeal was allowed since December 2024, but till date it has not. Rehabilitation.
Despite F423, despite direction on tribunal not taking salary for last 2 years, F4 lordship 55 by Thursday. Thursday, matter.
2 years.
Thursday pay, my lord.
2 weeks.
2 weeks. What is there? 2 years ago.
Not getting salary, my lord. Discharge, my lord.
Your lordship stand approval.
If I take only mood memos, what about the pending?
With your lordship stand approval, lord.
2007, my lord.
Now there are about 78 memos are moved. Yes, give viewers.
2007 April.
2007 and 2 weeks. They can change.
The matter relating to appointment of contractual teacher, my matter of 2024. It has been solved.
Pardon, my lord. Admitted balance payment of the contractor, but they are not releasing that.
Next week. Where is that?
Stand the approval. Item 7 of second weekly list.
Weekly list. You want time?
Not 1 week because
Weekly list. 2 weeks.
My lord, I will pardon my lord.
Lordship, in fact, these two matters, my lord, it requires lordship kind interference and take up the today lordship, reason being lordship. Lordship kind, matter relates to restructure of.
along with other matters.
Matter relates to lordship, restructure of this lordship, federation's lordship. And by virtue of.
Restructure of?
Well, lordship, there is a block level federation's lordship, which is coming under the lordship special department of the state government. And lordship to accommodate self-help groups lordship. These federations have been created only to accommodate especially to the women of the state lordship.
When it happened?
Lordship, in fact, lordship,
When it happened?
lordship, it is since lordship, like 2018 lordship. Now lordship, the state government in the 2025 came up with a policy for restriction of this
25 of
January lordship. And that has been stayed by this Hon'Ble Court in different writ applications.
when?
Lordship, that stay lordship passed on lordship that on 22/4 on 25. We have filed some different writ applications and that was never come up from the board lordship. But lordship, while modifying that order lordship, court has last lordship that is on 3/9/25 has come up with a modification order that
3/9.
is 3/9 lordship. Only this order is applicable to the pending writ applications lordship. And lordship, immediately government thereupon 4 came up with a notification and go on and enforce the order lordship. So our interpretation pending before the Hon'Ble Court without an interim order. So that is the peculiar the same order to passed and the matter has been adjourned to the 9th September lordship.
Day after tomorrow.
Lordship, tomorrow lordship because of the day tomorrow. Grateful lordship.
Day after.
My lord, with lordship permission, my lord, we have the teachers continuing, my lord. 2013 we have given some benefits. Now the government pass order to recover and the inspector of school has given notice to recover for my salary, my lord.
When it was given?
12/8, man.
12/8.
Again.
Today is
4/5/8, my lord.
4/9.
My lord.
4/9. Next.
No, tomorrow, my lord. They will now collect from my salary, my lord. Because
Salary is payable when?
my lord,
Salary is payable when?
well, 30.
Month end to give it. So you should have knowledge of service laws when salary is paid. The item number.
One request, my lord.
Tomorrow.
In 2 weeks, because deduction happens on the last day of the month.
Well, now they have already prepared to collect, my lord.
Two
They
writ
will-
applications,
Next.
two writ applications involving rehabilitation appointment. The government has come out with.
Yeah. I'm sorry, my lord, item number 4 of the weekly list. 4. Somebody. Item number. Yeah. 4, 7. 4 you want? 4 minute actually. Yeah, I want next week, my lord, because I am not getting salary. They have given the copy only a Friday. So, next counter. Next inform your friend.
Item 24 weekly list.
24.
Yes, my lord.
May not reach at all.
I press lordship next week.
Week after next, 24.
24 weekly.
24. Week of. 80. Why 80 will not reach? Don't worry about it.
After registration. And item 11 also after.
Why? Supplement. Why after vacation? For whole after 1 month you have difficulty. 11. Which matter? Which year? Which year? 25. After vacation. You inform the other side. Government.
80 also same after.
80 hours. Weekly.
Yes, item number 5. Also remember that the builder and allottees dispute. Well, your lordship, they suppose today the builder supposed to we remain present before this. Well, the difficulty is, my lord, he is coming today, my lord. He is
Coming today.
He is outside.
Outside.
Yes, my lord.
What time he will come?
The arrival time is, my lord, 6:30.
Evening 6:30.
Evening 6:30.
We'll have it tomorrow.
Day after tomorrow. Tomorrow I have.
Day after.
Day after tomorrow I have also informed my lord.
Three of the part owners are also present.
They are here.
Yes,
They are from which place?
they are from Bhubaneswar.
Bhubaneswar. Let them come on that day. He is having some difficulty. Huh?
About them.
Day after.
Day after tomorrow, my lord.
Day after.
Pardon, to make a mention, my lord.
As the top of list, only exception because one of my neurosurgeon, he will have a operation at the usual schedule is always after 2 p.m.
We will have it after 2 p.m.
Before 2 surgery used to be after.
Before 2 p.m. we
So
can.
if it is on the top of the list,
You mention him. Afterwards we get him.
They are in the top of list, my lord.
Pardon, to make a mention, my lord. My lord, in this matter, we have already completed our work and raised our final bill before the opposite parties.
Don't argue. When do you want?
My lord, maybe tomorrow. I cannot, maybe tomorrow.
Call this next. Which year matter?
My lord, 2024.
24?
Yes, ma'am.
3 weeks.
Yes, my lord, this is the third mention memo after notice at 2024.
24?
Third mention.
There are many older matters, na? Yes.
Pardon to make a mention, my lord, the petitioner challenged the action of the opposite party to regularize his service from the period of 2013 to
2 weeks.
2020.
Give it 2 weeks.
My lord, these matters are for listing. And these matters were filed in the last month of August. It's regarding to the scale of.
Give it 2 weeks.
I don't know. I don't know.
One time,
One in 10, serial number 10. Which is that matter? Supplementary. All right, after 2 weeks.
after notice.
But you should inform the other side. If the other side comes and starts arguing, I have to hear the matter in your absence. Because unless you inform them, they will be waiting here. Don't make them wait in the court hall. Court hall is not a happy place. Yes.
Your lordship, fresh matter, after notice matter at 24 matter, your lordship.
24?
Your lordship.
After 3 weeks.
99 lordship.
19.
Your lordship's order cover judgment there, your lordship also.
When it reaches, you can make her.
99, for that only I am saying. Item 99.
99?
Yes, your lordship, that rehabilitation assistance scheme contract.
No, this list we have to complete. Then we will go to the other list. At that time you mention. I'll take it.
Pardon?
You want time or what? Do you want time?
No, I am not asking.
You want disposal?
Yes.
Wait.
Fresh admission matter. Fresh admission matter.
I don't know, lordship.
Next week, put all over.
I don't know, lordship, my lord. Item 35 of second list, please adjourn this matter. Yes, ma'am. Second list.
3 weeks.
My lord, item number 69 of weekly list, second list.
Second.
Next week, man. Next week.
2 weeks.
I beg to
Weekly
go
list, 69.
weekly list item 24.
I have prepared weekly list going out of the way
1 week.
so that you will be prepared. You will not tell me that I am not prepared because yesterday night I got things. So that it is a warning. We will not damage. I will not damage any matter.
My lord,
Only thing is somebody
I am applying for the OP.
in.
I don't know 24. There is an interim order passed by the.
What do you want?
I will also next week interim order to continue.
Interim order to continue. Call out.
34 was adjourned. Read by somebody. Item 24 was adjourned.
It is 24 is your matter. 24 is your matter.
Yes, my lord.
Whether it is his, if you take others matters urgent.
Susan Kumar Das and so item 2. There are 2 matters, my lord.
2 weeks interim order. Wherever you are adjourning the matter, wherever there is interim order, continue that till next day.
Let's see, item 55.
Yes, sister.
Item number 55. Counter, please notice, counter affidavit not filed to file.
What you want?
Kindly fix the date.
We give you time of it. 3 weeks at the request.
Pardon, my lord. Item 27. Can we 2 weeks after, my lord?
3 weeks. 27.
27. On behalf of Rajugram Mahanto. Supplemental list 26. 33844.
You have written it on your palm itself.
No, sir.
Sister, what's your matter?
My lord, kindly take up item number 7. Kindly take.
Obvious, my lord.
7.
Item number 7.
In weekly list,
Name.
first list. We'll take up with
After next.
after vacation.
Item 7.
You want to object to adjournment? Then be seated. When it reaches, you can.
When we are all there, my lord.
Yes, you are there.
But
We are all there.
Yes. Let us.
You segregate your case.
Let us.
Item 7, it is there, my lord.
my
Then they are objecting. I will not give. Yes.
The difficulty is that, your lordship, there are group of matters. We are ready, your lordship, my.
We'll take up. We'll take up. Yes.
some matters are.
No, purpose. Yes. Your friends, you have to convince your friends, not me. Yes.
My lord, reproduction of 2023 is pending since long, my lord. Identical cases of 8 people are pending.
Yeah, give memo.
2023 is pending.
Huh? You have to move a memo. You send memo with your clerk. Our court officer will receive that.
Yes, my lord. Today I am filing a memo online, my lord. Kindly be listed for tomorrow, my lord.
Where have you moved? We have to make an order now. So bring memo.
Yes, my lord.
For the husband, item.
Brother? Largely, I have agreed with your contention. Largely, I have rejected your contention. Okay? I have referred to relevant of the decision cited, including Rahul Shah. I have referred to one decision out of 5 which you had cited. Other things are well established, therefore I have not treated. Then I have referred to Chitti on contract. And I have treated the doctrine of privity of contract, but he said that he was not a party to the settlement. Then he said that contract is frustrated because of Godavarman judgment and because of Forest Conservation Act, Wildlife Protection Act. These things also I have treated. Then lastly, the doctrine of frustration of contract also I have treated. Then after that, I have allowed the execution case this way. The judgment debtors are directed to supply to the decree holders the quantity of logs of wood under the forest contract in question in terms of settlement as recorded by the Apex Court in Civil Appeal number 6263 of 1979, disposed of by common order dated 27/3/93 through the Orissa Forest Development Corporation within 3 months. After and subject to deficient of stipulated payments being made good by the decree holders with simple interest at the rate of 6% per annum. Record from 22 to 1997, the date on which their execution case number 3 of 1995 was dismissed by the learned civil judge Karachi. 6% interest you have to pay. Alternatively, suppose logs are not available. I can't send him back saying that logs are not available, biscuits are not available because you have already taken the money. Therefore, I have structured alternate prayer this way. Alternatively, the judgment debtors are directed to pay to the decree holders within 3 months the present market value of the quantity of the logs of the nature minus deficit payment with the interest as mentioned in the previous direction. Deficit amount, whatever amount you are liable to pay. Installment. On that interest, that component to be minus from the value of the logs which he has to give to you. Third one is, the judgment debtor shall pay to the decree holders within 3 months a sum of rupees 2 lakh only by way of exemplary costs, since they are responsible for a slew of avoidable litigations which the decree holders were driven to fight for decades. This amount may be recovered from the erring officials in the department in accordance with. Fourth one, by this order nothing will come. Many difficulties may arise, and this being the Court of Execution under Order 45, Rule 17.
Rule 15.
15. It is open to the parties to move appropriate applications if needed for giving effect to this order or for any clarification or for removing the difficulties that may be encountered in its implementation. I have referred to that article which says every civil authority should abide by the apex clause. 144 of
144.
144 I have referred to, and I have referred to pre-council judgment in 1871, and I have also referred to few other decisions. The difference between a contract and a compromise decree, and contract becoming void or agreement being void ab initio. Because I have taken that way, like believers Dharmadas. I have not referred to that, but those principles I have stated. All right. Thank you so much. I have treated, I have appreciated you also. Thank you.
I'm grateful.
This 50 years have gone. 50 years. 50 years.
I think this is the solitary case which has been pending for last 50 years. I'm grateful.
Thank you. Very erudite arguments both you had submitted.
Thank you.
Very best performance. I enjoyed hearing both of you. I took more time because you took more time to give me the write-up.
Actually, there was a holiday, so I could not.
That's what. And
I'm sorry for that.
Ganesh festival also.
Ganesh festival. Great.
Press admission, item 2.
Yes. Small changes I need to make, some embroidery work. Okay, thereafter I release that judgment today itself.
But this is second round of litigation.
Yeah.
Well, the dispute is relating to publication of B.Ed result.
B.Ed?
B.Ed result.
B.Ed result?
B.Ed result by Berhampur University. In the first round, Your Lordship passed an innocuous order directing the Berhampur University to take a decision in the matter. Now, Your Lordship may kindly turn to Annexure 6 at page 19.
First time it has come?
First time it has come.
Take notice.
Yes, I will take notice.
University lawyer, sir.
University lawyer.
Any university lawyer is here?
No. Well, so far as Berhampur University is concerned.
Issue merchant.
Yes.
Returnable within 3 days. Next.
I will take notice so far as the opposite party number 3 is concerned by speed post.
Yeah, to everybody by speed.
Yes. Okay.
Next.
Item number 3.
Madam, in this case, I want more time for preparation. So next week,
more time to prepare.
Next week, madam.
It is relating to OTT examination. They are Supreme recently said that if they have within 2 years they have to acquire OTT certificate. Otherwise, they should be driven out from the service.
Next week, madam.
Next week. 2 weeks. The request. Yes.
Item number 4.
May I please, Your Lordship? The petitioner who is a MSME unit has this honorable court seeking direction to the state authorities to implement their own preference policy. Your Lordship may kindly come to.
Have you made the representation?
Notice may be issued because they have been despite there is a state policy which has been approved by the. I have approached. I have filed representations, my lord. That is, my lords. Annexure 11, my lord, and the first one is, my lord, Annexure 11, page 160, my lord. Sorry.
It is your representation.
My representations, my lords.
Not given.
We have been taught in the law school.
My lord.
If you want any mandamus, there should be demand.
My lord.
And rejection by the other side or sleeping over them. Otherwise, unless you make a very special case, I will not interfere.
My lord, here annexure that is 150, my lord.
150.
150. Under annexure 9 series, my lord.
Sure. 150.
My lords. It starts from 148, my lord. I have filed number of representations before different authorities, my lord.
Saying?
Saying that they should take steps for implementation of their own procurement preference policy 2023, my lord, wherein the state government has framed a policy that certain items, red contract listed items, are to be purchased from the red contract holders instead of going for tender, my lord.
No, but that is not your prayer in the representation.
My lord.
At 150, that is not the prayer.
My lord, my prayer is that, my lord, they have to ensure that, your lordship may kindly come to. I have given specific allegations therein where they have violated the procurement preference policy. Also, kindly have a glance at the procurement preference policy, my lord. Your lordship may kindly come to page 80.
Let them consider your representations in a time-bound way after giving opportunity to you. And if you suffer adverse order, you come.
Well, they are continuously violating the policy. That's why
we have given the representation. We will fix a particular period for consideration of that. If they don't do, come here. We know how to make them do all that.
That is under Annex 9 series, my lord.
9 series, na?
But can I suggest, my lord?
Yes.
Let him give a fresh one, reiterating all his grievances in a nutshell.
Along with
So
this,
that-
give a comprehensive representation.
Comprehensive representation so that matter can be.
The short grievance of the petitioner is as to non-consideration of a slew of representations at Annexure 9 series, wherein inter alia he has sought for a direction to implement some MSME policy.
Procurement preference policy 2023.
Policy 2023. First, Learned Counsel for the petitioner argues that when representations of the kind are given, it is the bounden duty of the state and its functionaries to consider the same so that the state policy is implemented to the benefit of class of people intended. First, this having not happened, Learned Counsel submits, this court should come to the aid of his claims. First, he also quotes Article 350 of the Constitution of India in support of his contention. First, next paragraph. Learned AGA, Mr. G, on request accepting notice for the official notice.
My lordship will dispose of the representation. No notice will be issued to me also.
That's right.
No notice need be issued. This matter will be disposed of. So,
because we are telling you to take the representation.
Yes, exactly, madam.
Fairly submits, fairly agrees with the suggestion of this court that the subject representations should meet their weight in accordance with law and in a reasonable First, however, he puts a caveat that all contentions of the party should be kept open and that the petitioner should be directed to cooperate in the process. First, with this, Learned Counsel appearing for the petitioner is agreeable. Next, in the above circumstances, petition is disposed of. A period of 2 months is prescribed for disposing of, considering the subject representations at the 9 series, and also to inform result of self-consideration to the petitioner. First, to facilitate easy and effective consideration, petitioner is at liberty to file a comprehensive representation along with the material vouching his claim within 2 weeks.
Specifically to which opposite parties he will give
OP number 1
to OP number. Okay. OP number. All contentions of the parties are kept open. Next one. It is open to solicit any information, document from the side of petitioners if necessary, so. At this stage, no courts. Yes. Next. Web post copy to be acted upon. Yeah.
Item number 6.
My lord, applicant retired on 30/9/2020, my lord. And that is 1 day prior to his date of increment, my lord. And there is an office memorandum as per NHF 4, my lord. State government employee retiring a day before their date of annual increment grant national increment only for the purpose of pension, my lord. And identical case also passed order, your lordship, my lord, as per NHF 3. But in my case, I have filed a representation as per NHF 5, my lord. They rejected on the ground that Finance Department again passed a resolution as per NHF 6, my lord, that they have rejected that it is to be affected only retrospectively on 30/9/2021, 30/9/2021, my lord.
Alternative AG, Mr. G, on request accepts notice for the OPs. Call after 4 weeks, since matter lies in a narrow compass. And it is a second round of litigation. Second round of litigation.
Yes, my lord.
Next.
Item number 7.
Wait, please, Your Lordship.
Yes.
My Lord, I'm in WPC number 1785/2024. My Lord, all the cases, facts are similar. Now the question involved, Your Lordship, that the petitioners were granted the license of Mohammedan marriage, Registrar of Mohammedan Marriage and Divorce. Under Mohammedan Marriage Registration and Divorce Act, 1949, Odisha Act, Your Lordship.
Odisha has separate act.
Yes. Mohammedan Marriage and Divorce Registration Act, 1949. And it has got its rules also. They have annexed that act.
Give that.
In the counter, they have annexed the act. Yes, Your Lordship. Now, briefly, I am submitting the fact.
Local government servants.
Government servants. They are all
doing that job, and you will be registrars also.
Yes, Your Lordship. That is the question involved. Your Lordship, that matter, my Lord may kindly permit me to place the order dated 23/7/2025 passed by this Honorable Court.
23/7/25.
My Lord.
What it says?
My Lord, I am reading it, Your Lordship. That is in the common order passed. Order number 5. This hard learning council for the parties. May I read, my Lord? 23/7/2025. Passed in WBC, all the rates were mentioned, 17429/2025. My Lord, 23/7/2025.
Go to para 5.
My Lord. Even though such a plea was taken by learned additional government advocate, this court, after going through the provisions of the act, nowhere finds any such bar in allowing a government employee to discharge the duty of a registrar in addition to his original work. And my Lord have directed to file us an affidavit. That affidavit is at flag 10. In the previous paragraph 3, it is mentioned. Paragraph 3 I am reading also.
Which is the bar learned coordinate judge wants to find in?
That is paragraph 4.
In the act.
In the act, it is mentioned by the learned government council that there is a bar.
Let there be no bar. For example, suppose Excise Act.
My Lord.
For government servant, that Excise Act does not say no government servant shall open a parak shop. There is no such provision. I read the entire act in connection with some case.
My Lord.
That bar need not be in the said act itself. It can be elsewhere.
My Lord. My Lord, with respect, my Lord, that also, your Lordship may kindly consider.
You are all government servants. You should do government job.
That is
job. It is not illegal.
That is with respect, your Lordship, not being hampered. We have filed an affidavit because, your Lordship, what has happened? The Mohammedan marriage register can enter the marriage or divorce, in the case may be, within 1 month of the marriage and divorce. That is the rule, and that is not disputed. Now, if it is within 1 month, your Lordship may consider, even on Sunday or even on a holiday, I can make an entry only. My duty is only to enter. I am not a Qazi, your Lordship. I am only a registrar of Mohammedan marriage. Now,
the remuneration you will get? No.
That is exactly the affidavit your Lordship wanted.
Then what is your civil right under Section 9? Right to sue under section 9 of CPC.
There is an office, might be an office, need not be of office of profit. It is an office. It is not an office of profit.
Where is the office set on here?
That is, as per the law, my lord, my prayer is that, your lordship, since 2001, they have granted me the license. 23 years I have performed without any difficulty. They sought for clarification in 2005, 2009, 2010. As to my job, every declaration in a format from my school, from me, from director of...
What are you?
I'm a teacher, your lordship.
Teacher.
My lord has...
all petitioners are teachers?
Yes.
All they are teachers?
Except I don't know, second item.
Second item. What is it?
I am applying for the post, since they are occupying the post.
But here preference is required Arabic language.
Only one
having known Arabic language.
One clarification.
Only teachers know, others do not.
Some people are having Arabic language.
Only your lordship has put a question that restriction might not be there, might be in other laws. That is Odisha Government Servant Conduct Rules, 1959. Section 17, I've just got the Xerox copy extract. It is a big volume, so only for easy reference. Relevant section is section 17. I am reading, my lord. No government servant shall accept, with previous sanction of the government, engage directly or indirectly in any trade or business or under any employment. Provided that a government servant may, without such sanction, undertake honorary work of a social or charitable nature or occasional work, a literary, artistic or scientific character subject to following conditions, namely, he shall within 1 month of his undertaking any such work report to the government giving full details. His official duties do not thereby suffer, and he shall discontinue such work if so directed by the government. Provided further that if the undertaking of any such work involves holding of an elective office, he shall not seek election of any such office without the previous sanction of the government. Thereafter explanation. Now, we have submitted the reports that has been called for. Everything has been disclosed. From our side, there is no suppression of the fact to the government, and we are continuing. My prayer before your lordship, the rule under the act clearly says it is not a government post. Now it is, he holds the office as a public servant while performing that act only, but it is not a government post. Your lordship directed by the same order 27/2025 to all of us to file affidavit that you have never taken any amount, you will never take any amount in future. That affidavit...
Where is that act? Give one copy of the act.
That is, your lordship may kindly see, in the counter,
No,
that is in base.
Do you have any hard copy of the act?
WPC number 708 of 2024.
I have quoted.
Friend has...
I have quoted, my lord.
You have quoted entire act.
My lord,
No,
in the notes of argument also.
They give the whole act. So that just I will...
In the counter they have annexed, my lord. In the counter they have annexed.
In that
Government has annexed the entire act in the counter.
we have annexed the rule. Mohammedan, Orissa, Mohammedan marriage and divorce registration rules. And actually, A by 1 I had annexed.
Yeah.
Page 489. 489. Volume 12.
Their applications are pending before you.
My lord.
We have been granted license in 2001.
You have said it twice now.
My lord.
I am asking a question. New question, new things.
My lord.
No, Charvita Churnam. In Sanskrit, there is a saying. Charvita Churnam means what is already beaten need not be beaten again because it will not yield even one drop of oil. Yes. Their applications for license are pending or rejected.
It is pending probably.
My lord, so far as our applications, our licenses are concerned, our licenses are revoked by the order
We
of
have been granted since 2001. Thereafter we have been performing. It is revoked.
Case wise.
Let me submit my...
In which cases they are revoked? Which are those WP?
That is
WPC
1785 by 2024.
1785
by Mohammed Akhtar Ahmad versus State.
rejected.
That is
Rejected or pending?
that is 13 and Mr. 13 revoked.
That is WP 1785 of 24.
My lord.
My lord, my case, my lord. WPC 43137 to 2023.
WP
43137 2023. As well as 708.
WP
708 2024.
rejected.
Revoked. License revoked.
Then
My application is pending.
which in rest of the things are pending.
Only one is pending, other license were revoked.
His application is pending for consideration.
Yours is also revoked.
No, mine is revoked.
Your WP is
WPC 1785 of 2024. Second item, 3651.
only one matter it is pending.
Yes, ma'am.
That is 33651.
1 of 23. I applied and
Now your first contention is that there is no prohibition in law.
9 and 10.
9 and 10 are pending.
And section 9 and 10 of the Act.
I read 9 and
My lord, first of all, your lordship may kind enough to visualize what is the act. An act to provide for the voluntary registration of Mohammedan marriage and divorce in the state of Orissa. That is the heading.
If parties want, they will do, otherwise they will not do. Voluntary it is.
Voluntary. That is the act.
Understood. Then
Section 3, my lord. State government may grant license to register.
Section 3.
My lord,
It shall be lawful for the state government to grant a license. Means what? It shall be lawful for, which is that Supreme Court judgment, which defined what it shall be lawful means. Surendra Malik's asked quotes Supreme Court and words and phrases. Ask the librarian to bring that. There are 3 judgments of the apex court. What is meant by it shall be lawful for the government to do. All right. You have done any research on that? Not done that. I will do that. All right.
Section 9, my lord.
Section 9.
Section 3.
Duties of Mohammedan register on application.
Date
of the marriage. Your lordship, here every application for registration under section 8 shall be made within 1 month from the date of marriage or divorce.
9. Duties of Mohammedan Registrar on application. Every application for registration under section 8. Let us read it. Every application for registration of marriage or divorce application shall be made to the Mohammedan Registrar orally as follows. The application deed for the registration of marriage one is the allotment of lease with the parties to the marriage jointly. Provided that if the man and the woman are both minor, such application shall be made on the basis of the respective of the body. Application of the registration. Such if the application be for the registration, they was other than Kula or Salah of by them. The application be for registration, they were of the Kula with the parties to the divorce time. Project of human be for the nation. The application need to registration of the divorce of the time. One has it awkward action. Provided Duties of Mohammedan Registrar. Every application for registration has to be made. So 1 month payment to 1 rupee. The Mohammedan Registrar shop. You are entitled to 1 rupee.
1 rupee for certificate.
Issuing certificate.
Certificate. Where is certificate?
Where is that? Section 9 speaks of registration only. 1 rupee for registration only, not for certificate.
Registration fee, there are also rules provide that.
This 1 rupee will go to whom?
State.
To the state.
And how?
1 rupee to the registrar. Why state? As I said clearly, registrar will be received 1 rupee. If the application for registrar
On payment to him, it is the registrar. Him is registrar. Yes.
Section 10.
Section 10.
Mohammedan Registrar may receive gratuity.
Gratuity. Nothing in the preceding section shall be used to prohibit a Mohammedan registrar from receiving a gratuity in excess of the fee provided in the petition of when such gratuity is voluntarily tendered. Ten.
19 and 20.
Really give us.
Rules have been promulgated.
Yes, sir.
My lord, rule 14 may kindly be seen, my lord. Rule 2A1 as well as rule 14 may kindly be seen, my lord.
Page number?
Rule at page.
In this book, which is the page?
My lord. Rule 2A.
Rule 2A.
My lord. But at page 498.
498.
Shall be within a period of 30 days.
Next words.
The rule 14. License. Not a government.
License limits the end of the moment is license to qualified persons who have been approved to be Mohammedan registrars will be granted in Form B or license to qualified persons who have been approved to be Mohammedan registered. Who should approve it?
State government.
State government. Where is that?
State government under section 3. 3 of the act.
Section 3.
State government may grant license to register.
No, where this rule says approved.
The procedure prescribed in rule 4.
Rule 4 for approval. No, where is that approval? Where is the approval procedure? Whether your names figure in Form B.
Yes, ma'am.
Form B.
Yes, ma'am.
Where is that? Show that.
In my interpretation, I have done it.
Take out the. It shall be lawful. Take out somebody may help us, some youngster. Give that book to them. Please help us. What is meant by it shall be lawful for the state government? There are 3 judgments of the apex court. Yes, please.
My lord, the license that has been issued to us.
No, you are not answering the pointed question. Question is, Form B is referable to Rule 9. Correct? Who approves? What is the approval procedure?
License to qualified persons who have been approved to be Mohammedan registered.
Approved, their name should appear in Form B. Only they can make application. Whether your names appear in Form B. Show them. That's the precondition. If at all you have any right. Who all have Form B enrollment?
Yes, ma'am. I have.
You have. Which is your petition?
Last one, madam. 19,436 by 23.
Go to sir's annexure. Which is annexure, sir?
Annexure, I have annexure. Form number. Annexure 1, 9, my lord.
In your WC. Number? Got it. What is meant by just read? Give that. Give that to us. Sir, read that. So that many students will be here, youngsters will be here. They want to learn. I also want to learn.
It shall be lawful. The word it shall be lawful used in section 105(1) of the Indian Companies Act 1913 and the word may used in section 76(1) of the Companies Act 1956 mean the same thing. And both these sections were enabling provision that intended to legalize something which was previously illegal. In Julius versus Bishop of Oxford, 1980, it is said the words it shall be lawful are not equivocal. They are plain and unambiguous. They are words merely making that legal and possible, which there would otherwise be no right or authority to do. They confer a faculty or power, and they do not of themselves do more than confer a facility or power.
Put the flat. Yes. Whose name appears in Form B?
I not my form.
Show that Form B. Your Form B. This is in WB.
19,436 by 25.
You are all your working teachers, no?
Yes, sir.
Anything, articulation,
number
you want
nine,
to
Annex
ask
one.
anything? Anything more than this?
My lord.
Yes.
my lord. My lord.
Your first ground, just tell, write down, sir, first ground.
My lord.
First submission.
My lord. My
Give dictation.
Impugned order.
My lord. My submission, your lord,
Yes,
says.
write down.
As per Annexure 13 in my read, the order has been
Writing down.
Impugned order, madam.
impugned order.
That's not the question. You have to articulate your point.
Yes, your lord.
Now give dictation. Write down.
My lord.
You are his steno now. Yeah.
My lord.
Articulate the point.
My lord.
Better if they will submit a written note of.
Written note we have submitted. We have already submitted. As your lordship says, my lord.
Case number
The
708.
my lord, I am submitting. The petitioner was granted the license of Registrar of Mohammedan Marriage and Divorce on 12th July 2001. Thereafter, your lordship.
No, where is the articulation? You are only narrating the facts.
My lord.
Articulation of law.
Point of law, my lord. My lord. The point of law involved whether a person acting while my lord. Whether a person while acting as government servant can also simultaneously perform the work of Registrar of Mohammedan Marriage and Divorce. Marriages and divorces.
Registrar of marriages and divorces.
My lord.
That's the question.
That,
What is the proposition?
The respectful answer to that question, your lordship.
Yeah.
As per rule 18 of the Government Servant Conduct Rules, any government servant can perform which is social or religious nature and where he is not benefited in any way. That, my lord, that's the Government Servant Conduct Rules.
Of the conduct rules. Come on. It provides for any government servant to undertake any activity that does
17.
not.
Extremely sorry, your lordship. 17, as per 17.
Rule 17.
My lord.
17. But you are getting 1 rupee.
My lord.
Yes.
That, your lordship, that 1 rupee, your lordship may consider. Now, it is also in the rule, it is provided that some extra amount even beyond that may be given.
No, rule says.
My lord.
It shall be non-remunerated.
No, it says that 1 rupee will be given.
No, conduct rule.
Government conduct rule 17 says.
Non-remunerated.
My lord.
But there is a remuneration of 1 rupee. 1 rupee is also remuneration.
My lord. But to that effect, your lordship, my lord may consider that we have also submitted an affidavit to the effect that we have not taken and will also not take.
That makes no sense.
My lord, I understand, your lordship. But your lordships made a query to us and we submitted an affidavit as per your lordship's direction. That we have not taken and will not take also any fees and we have never taken also. Any investigation may be made to that effect, we have complied.
Whether that rule gives option not to take. Read that rule.
No, silent.
It is mandatory.
No.
Because it's a public office.
Yes.
There cannot be a public office or public duty without remuneration. That's the reason why Harish Salve was given 1 rupee to argue Kulabhushan's case in International Court of Justice. 1 rupee per day. Similar. You can't say, I will not take my salary. You are bound to take salary because you have to uphold the grandeur, efficacy, and glory of the public office. Therefore, salaries attached to public office cannot be attached. In CPC section, which is 60?
60.
Yeah. Where is option not to take? You are bound to take. If you are bound to take, then you will travel to 17. You cannot seek shelter under 17 at all.
That your lordship may kindly permit me to place rule 19.
Yeah.
That is 1976 rule framed under that act. Now, disposal of fees. The fees received by a Mohammedan registrar under section 10 and 16 of the act may be retained by him as his lawful remuneration, provided that he duly pays for registrars and other articles supplied to him under Rule 16.
All fees.
All fees received by a district registrar shall be
Not
credited.
you,
My lord.
district registrar.
No, the option is given to me to deposit it, your lordship. I am reading it again. Disposal of fees. The fees received as the fees received by a Mohammedan registrar under section 10 and 16 of the Act may be retained by him as his lawful remuneration. That is Rule 19.
No. Up to section 9. A rule cannot run counter to the section. Section says you shall charge 1 rupee. Rule cannot say you can give back to the government. A child cannot be older than the mother.
My lord.
So it's a remunerative office.
That section 9 says, your lordship, 1 rupee. That section 9 says that.
It's a public office. It's a remunerative office.
So far public office is concerned.
It's a public office.
That we do not dispute. But not a government office as mentioned.
No, public office, it need not be. Every government office is a public office.
Not
but
the
every public office needs to be a government office. But it's a public office. How can you hold a public office? Already you are holding a public post.
That your lordship may consider.
That I am considering now.
My lord, my submission with respect to your lordship.
Yes.
Now, if it is hampering my work, I cannot say anything.
It's in the opinion of the government says. Question is, there are rules which say you will not conduct tuition, and Apex Court has upheld it. You are teaching, you are giving tuition in the classroom, but it says you shall not give tuition in your house. Same job.
Because there may be conflict of interest.
Where is the conflict of interest?
Those students, those who are reading there, if private tuitions will be given to them, that may not be, that is not proper. It doesn't appear. But here it doesn't come in any way in my work. Your lordship may kindly see what has happened, your lordship. Since 2001, we have been performing.
You said that about
they have asked us to submit all assets, liabilities, and every disclosure we have made.
Yes.
Thereafter also they continued. Now on the ground they have revoked that probably it may come in conflict with her. If your lordship will permit Annexure 13, I'll read that person also. Rule 17, that apart from that Rule 17 of the Odisha Government Servant Conduct Rules, 1959 contemplates that a government servant can undertake honorary work of a social or charitable nature or occasional work, literary, artistic or scientific character without suffering his official duties.
Yeah.
In the instant case, a government teacher is supposed to remain in duty throughout the day in teaching the student in the school, and therefore he cannot devote any time for registration and divorce of Mohammedan during school hours. Although there is no express provision either in the Act or in the rule prohibiting government servant, but on conjoint reading of above 3 acts and rules, it implies that a government servant cannot be given a license. There is no prohibition, your lordship. And what has happened, why they have stated so? In the counter, if your lordship will permit me to read paragraph 14, that is clear. Why they have, it is with respect, your lordship, it has been misconceived by them. It means, just a minute, it means, I am reading paragraph 14 only, yours. It means that when the marriage is celebrated, the presence of Mohammedan registrar, within bracket Kaji, is absolutely required to solemnize the marriage nikah ceremony between the bride and the groom. It may not be out of place to mention here that without the Mohammedan registrar Kaji, the Muslim marriage nikah is not possible at all. With respect, your lordship, this contention counter paragraph 14 is not proper, your lordship.
It is irrelevant also.
My lord.
Faizi on Mohammedan law says Kaji is not necessary.
Not required. And even Mohammedan registrar is not a Kaji. So that they have confused in the revocation order, so also is reflected in the counter. They have confused us with the Kaji. That is not a fact, Your Lordship. So my respectful submission that since they have been continuing without any complaint from any side and there is so maybe the revocation may be cancelled.
New
Rule 37.
37.
Rule 37.
Great.
Rule. Rule 37.
No.
5C on Mohammedan law.
Yes.
Says yes, the presence of Qazi is not essential
Yes.
for a Muslim marriage.
Yes.
Rule 20 says that attendance at marriage, where the attendance of Mohammedan register is required.
Yeah.
At the celebration of a marriage or other ceremony for party requiring his attendance and make an application to the Mohammedan register specifying the place and time of the marriage or other ceremony and that officer may attend.
He is not Qazi.
No,
Qazi, Khalqa, these are all Mohammedan officers, separate officers. What they are showing is the reason which the government has given may not be correct.
If a person requires his presence, he may attend. Who says?
He is not a Qazi.
He is not a Qazi.
He is a registrar. Qazi is a Muslim officer.
If Mohammedan wants the presence of the register may attend. Who says?
With application.
Not only that. Now registration and other things may not be problem at all. Suppose case goes to the court, then you will be called there. You have to leave the school and stand there. That will affect the interest of students. You are only ideally speaking of marriage which will not suffer divorce at all. There are divorces.
Yes, Lordship.
There are issues as to whether there is marriage between parties or not. It may be a criminal court. It may be a Qazi court. It may be a civil court. Then if you go and stand there, what should happen to the children?
That's where Rule 3 is there.
3.
Rule 3.
May I submit my
Please. Who may be nominated? A person who to be licensed has a Mohammedan register should have sufficient acquaintance with the Arabic language, Mohammedan law of marriage and divorce, and to be of good moral character. Preference shall be given. My lord, this is.
I have seen that.
Ordinarily,
only pensioners and others.
Yes, right. Exactly, my lord. Your lordship has last time rightly pointed out the maxim expressio unius
exclusio
ulteriors. My lord, means express mention on one thing implies the exclusion of the other. My lord, that's why, my lord, they are not entitled to, because they are all government servants, 24 hours government servant. It may be necessary to work at any hours. How they will come here to discharge the responsibility of the registrar of marriage? They are teachers.
May I submit my doubt? The Lordship has put a question that occasion may arise, sometimes he may have to attend.
Yes.
That is the case with many other government servants, Your Lordship. Even a government doctor.
No, that's inevitable.
Yes, Your Lordship.
But for you, it is not inevitable.
Yes.
See, teachers are very important. Therefore, in our culture, in our civilization, Guru Bhyo Namaha. First is Guru Bhyo Namaha. Salutations to the Guru.
Guru cannot distribute the responsibility of marriage registration.
There is a larger responsibility. You can't be equated to others. Number 2, you should also be gracious. There are other people, at least you have job. There are thousands of other Muslims who do not have job at all. What Prophet Muhammad said, Padosi. Prophet said, if you do not see the smoke in the neighboring house, don't cook your food because he is hungry. If that is so, why you want to monopolize everything? You leave it to others. Let others also will have their part of fruit, cake.
people are waiting after retirement.
With respect to Lordship, so far the present situation is concerned, no such conflict has arisen. I am submitting, my lord. Probably in my case also, that might have also same thing. There is an area within which we can perform the registration. It is not that entire district is under control. Previously, I was given within the town PS only of that Bhadrak district. Thereafter, Your Lordship, 10 years after, they have extended it to different PS. So far, Your Lordship, this 1 rupee is concerned. This
you want to see?
Rule 37, if Your Lordship will permit, I will place. In what cases fees may be refunded? That is Rule 37.
It's refunded. That's not
Received. Yes, Your Lordship.
That's not the question.
Received. That rule I am reading just, Your Lordship. That may fees paid under Section 9, that is the Section 9, shall not be refunded unless registration is refused for one of the reasons in clause 1, 2, 3 and 8 of Rule 34. Fees and travelling allowances paid for attendance of Mohammedan registers at the celebration of marriage shall be refunded only in cases where the Mohammedan register doesn't attend. Fees paid for searches in the registers and indexes or for copies of entries shall be refunded only when the searches are not made or the copy is not given. So, Your Lordship, that 1 rupees fees, my Lord may consider that may be, in some cases may be refunded, may not be. So, a joint reading gives an option that it is an option. It is not mandatory.
Leaders to follow. I have tested. Next, I have applied for license. My case is
that you which is that?
WPC 3651. I have
WPC?
WPC 3651. Second item.
You are not teacher?
Now teacher, I have applied. Since they are occupying, I have not you.
You consider that application?
Consider, my lord.
WPC?
3651 of 14.
Second one.
I have applied. In case of 2014.
WP 33651 of 2023, petitioner has applied for the privilege of being a registrar of marriage. His application remains unconsidered till date. He does not have any disqualification. And on the other hand, he has eligibility. Argues counsel for the petition. First, next. Learned AGA, Mr. G, fairly agrees to instruct his officials to consider the subject representation in a time-bound way in accordance with law if all contentions are kept open. First one. This is appreciable. Next one. In the above circumstances, petition is allowed. Time for consideration is 8 weeks. First, open to call for solicitation.
May I make a small prayer, my lord?
Of course, next. You should make the prayer before the appellate court. Yes.
Item number 8.
Yes.
My dear petitioners or interveners in a proceeding on Section 18 of the Telecommunication Act, our application for intervention was allowed at page 30 by order dated 4/4/2025.
You are made parties.
Intervention was allowed. On the same day, orders were reserved without giving us an opportunity to file counter and without giving us an opportunity to hear. That is yes, ma'am.
You are for petition.
No, my senior was the petition.
You are for
I am for opposite party number 2.
Notice is not yet known.
My lord, we were on caveats.
You are on caveat.
My lord, may I only state 2 facts, my lord?
No, whether fresh matter.
It's a fresh matter, my lord. Last occasion.
Who is for the petition?
I am for the petition.
Who is the respondent?
I am for OP number 2, my lord.
OP number 2.
My lord, private opposite party.
Private opposite party. And other official opposite parties?
All government, my lord.
Who? AGA or central government?
No, my lord, state government.
Issue notice. Will issue notice?
Yes, my lord.
Notice is already issued.
No.
That notice has to go.
My lord, if I may only state for 2 minutes, I'll not stand on the way, my lord. I'm only bringing to your lordship notice. My lord, the entire fact is, my lord, may kindly see the order which is impugned, the prayer itself, is against the order dated 22/4/2025. We are in September, this is in April. 22 April 2025.
Yeah.
Now, my lord, what was the order? The order was, my lord, the order was
to allow, it was my petition. My petition was allowed.
Anyway,
No, I'm only bringing, it has become infructuous.
their application was allowed.
I completely, no, it has become, it has infructuous. My entire point is this has become infructuous. I only wanted to bring that notice to your lordship because the order was to give police protection for me to install a telephone tower, my lord. That has been installed, it has been charged now. So today, in September, when we are standing, my lord, when we are taking it up, it has already become infructuous. I have also got other arguments, my lord, I can do after the notices are issued. I'll give, my lord, subpoena of judgment. Already installed and charged.
What has happened in the meantime, I do not know, madam.
No, he's saying that.
My officer is, should I not be given an opportunity to file a counter?
Correct. It has not been given. It's all right. Now, suppose the amputation has happened now. Amputation is done in the operation theatre. Then what should be done? You work out your remedy. That liberty I will read.
Dr. Kindly see page 30, not in short order.
30.
Proceed 130. That is order dated 4/4/25. The case record is put out today. Advocate for the petitioner and opposite party, number 5 are present. An intervenor petition has been filed by Sri Hatanath Sahu and Sri Mayadhar Karan, who are the petitioners. The same is allowed. The written statement filed by the opposite party number 5 forms a part of the case record. Peruse the case record, orders reserved. They are up to the final result passed.
Where did you object? Kindly do not reserve. I want to file objections. Where did you tell him? And what is there to tell more?
But in fact, our intervention once is allowed, then I must be given.
You should tell him. Now you are, sir, you are allowing intervention. And you are only an intervener.
Yes.
Not an impleaded party.
Not impleaded.
What is your right to challenge? Apex court said, intervener has no right to challenge.
Once an intervention is allowed,
no,
I am an opposite party.
That's wrong. That's wrong to say the least. Party is different, intervener is different. Which is that judgment? Go to Google. An intervener assists the proceedings. He cannot challenge the adverse order. That's the law. Therefore, when you are using the words, you should be doubly cautious. You can't use Oriya word in English. English has got its own meaning. Oriya has got its own meaning. If you mix these problems arise. Intervener is not just an English word. It's a legal concept. Can you take out that judgment?
Well, I'll just find it. I found one judgment, my lord, but I'll take
just
it.
read.
The proposition says the intervener generally supports a party and cannot challenge an adverse order directly, as they are not a primary party to the dispute, but are typically allowed to appear to assist the court or raise a specific issue. I'll give the judgment. Well, I'll give the judgment, my lord. I've got that. I'll just give the judgment.
Why are you not all updating? Whichever law, you should spend on time on law only, unless you have some other land where you will go and cultivate. Otherwise, law itself is your field where you should eternally cultivate it. Because in writ petition, which law will arise, who knows? It may be taxation law, criminal law, then marriage and divorce law, it may be international law, constitutional law, tenancy law, labor law, taxation law. Any law may come there in writ jurisdiction. Otherwise, this happens.
Well, there is a latest Supreme Court judgment. I'll give the citation. I'll give the citation, man. I'll just give, it's civil appeal number 4505.
The intervener in the proceedings pending before the authority under the provisions of
Telecommunication Act 2013.
Act, who was objecting to the permission to erect the tower. Tower. He is knocking at the doors of Red Court, alleging that the authority, namely the collector and DM Khurda, could not have made the impugned order on 4/4/2025 in as much as on the same day he had permitted intervener's application. First one. Next paragraph. Learned counsel for the petitioner submits that once the intervener application is allowed, the intervener has to be given an opportunity of participation in the proceedings by filing his pleadings, and that having not been done, the impugned order suffers from error apparent on the face of the record, warranting interference of this court. First, learned AGA appears for the author of the impugned order, and learned private counsel represents the private OP number 2, who has, it is said at the bar, constructed in all respects the tower in question and charged it to person. In view of that, the petition has become infructuous, says the private counsel. First, next paragraph. Having heard the learned counsel for the parties and having perused the petition papers, this court declines indulgence in the matter inasmuch as the intervener has no right to challenge the order of the kind. Wide apex court decision in
2025 SCC online, SC 1015.
SC 101. First, even otherwise, at this stage, matter would not require deeper examination, the mobile tower having been built and charged. First, next part. In the above circumstances, petition is liable to be rejected, and accordingly it is, reserving liberty to the petitioner to take up appropriate proceedings elsewhere in accordance with law. First, in that connection, all contentions are kept open. Yes.
Just a small indulgence, my lord. If I find another judgment, I'll just give it to
just give. That was a very old judgment which followed Lord Atkins' judgment.
My lord, I'll just find that out and give it. Deeply obliged.
You should always make notes. You should make notes, hard copy. You should make notes in the mind also. That comes immediately to your assistance. Yes. Yes, next.
Item number 9.
My lord, there are batch of cases.
Yeah.
My lord, in WPC number 16697 of 2025,
yes,
counter has been filed. And I have also filed rejoinder.
Yes.
Lords, I may be permitted to mention the rejoinder was served to me in the courtroom today. I have not gone through that. I need some reasonable time to.
But in one of the cases, rejoinder has already been filed by my learned senior, by my learned friend. My lord, but all the cases are identical.
Generally, he will not ask for time. He is very fair advocate.
But here,
of the fair advocate.
But here our predicament is.
What happens if it is taken next?
But the difficulty is the petitioner's result has been cancelled in CBSE examination in respect of class 12 for identical answer. But there is no adverse report from the side of the
no, that's not very.
Yes, yes.
What heavens will fall down if it matter is taken up?
But the examination notification will be made on 20th September for 2026 examination.
Before that, we will take up this matter. On this matter. On 10th.
Lordship, just similar to sub-item number 3, my lord. The pleadings are complete. Long back. Long back, it's identical matter, my lord.
Identical.
Same principle.
Identical matter.
Next matter.
Item number 10.
Yeah.
For disbursement for some period, duty period salary, my lord.
Duty period salary.
Ma'am.
That salary is not paid to you.
No, my lord.
Why?
Now, I am
between
not.
1/7/2005 to 10/1/2017.
17. Thereafter, petitioner some personal difficulty and resigned from service. Not in service now, ma'am.
He resigned on which date?
1/7/2017. That's it.
2017.
My lord.
You have filed writ petition now.
Well, earlier petitioner was approved before this honorable court. At Annexure 3.
Annexure 3.
Sorry. Annexure 2. I am annexing Annexure 2, my lord. 2, my lord. Page 12, my lord.
Dispose of the representation.
My lord.
And now it has been disposed of when?
Huh?
The impugned order is made on which day?
2018, my lord.
No, that was 10/7/2018 is the order of the WPC.
My lord.
Thereafter what
Thereafter,
happened?
the authority has not complied that.
Then contempt you have to file. Why another
Now-
petition?
My lord, time, but due to some personal difficulties, he has not approved before this honorable court due to non-compliance, my lord. Time already, contempt is 1 year, limitation is.
You make application for extension of the period. That's the way. You can't file one more writ petition. One more order will make, they will not pass that, comply with
Yes,
that.
my lord, thereafter, petitioner also approached before this, before the authority, my lord. That authority has not complied.
Not complied.
Well-
Now I make one more order. He will not comply. Again, he will come before the court. Other you will go to brother judges. They will make another order. There will be 20 orders, arguably, because 20 judges are there. They will not come. What will you do?
My lord, that due to.
You make application for extension of the period. Because otherwise it's a res judicata. One more order will not make. It is useless to duplicate the orders.
My pardon, my there before lesson, my liberty to approach the content.
Petition is filed seeking consideration of the request of the petitioner for payment of arrears of salary that is allegedly accrued during the period between 1/7/2005 and 10/1/2017. First, learned counsel for the petitioners draws attention of the court to the earlier order dated 10/7/2018 made in his WP number 1205 of 2018, wherein a coordinate bench had directed consideration of the request. First, counsel for the petitioner submits that despite that order, request has not been considered, and therefore a direction should be issued to the OPs to accomplish the task. First, just consider and take a decision on that.
Yes, filed. Annexure 5 yes, filed on March 25.
But the order is made in 2018.
There is some, his post was not approved.
Tell it to them, not to me.
You must.
I am not the petitioner, I am only a judge.
Yes.
Learned AGA appearing for the OPs submits that if some reasonable time is granted, a decision would be taken by the jurisdictional OPs in accordance with law if all contentions of the parties are kept open. First, he is reminded of the earlier order of the coordinate bench remaining unimplemented. First, he assures that the same fate will not happen again. First, next one. In the above circumstances, petition is disposed of, directing consideration of petitioner's representation dated
8/3/2025.
8/3/2025, a copy whereof awails at Annexure A5. First, this to be done within 2 months, and that would include communication of result of consideration to the petitioner in writing. First, at this level, cost is reluctantly made easy. First, it is open to the OPs to solicit any information, etc., etc. Regular point. Web copy to be acted upon. Yes, next.
Item number 12.
Yes.
Petitioner is a class 4 employee claiming regulation of his service from his initial date of appointment.
Initial date, we have already
Yes.
order.
Yes.
Notice has to go.
Yes.
Issue notice. First, call this matter along with WP number.
On behalf of OP 1 and 2, Mr. Panel Counsel SC Ratra appearing. The order shows them.
Shows that, the same one. Okay.
All matters are same.
Others are AG.
Yes, madam. 3 and 4 AG.
3 and 4 AG.
All
same order, na?
Yes, madam.
Any representation is given.
My service, earlier the petitioner approached this.
You have been regularized, but you are deviating of that.
Yes, my service was regularized in the year 2025.
No,
this
I'm
year.
asking you,
Yes.
did you give representation saying that you have given me some date, but date should be earlier? Have you given such a representation?
That representation has not been annexed.
You give representation, I will direct them to consider that. Of regularization. They have given later date.
Yes.
But it should be from the date of entry into service.
Yes.
But where is your representation? You give representation, I will direct them to consider it in a time-bound way.
As of matter or notice as
We have already disposed of similar matters now. I am only waiting for that batch to come.
already in similar matter.
Similar matters, notice were issued. Thereafter, some other matters came. We made this order. I am just waiting for other matters to come so that I will duplicate your order in those matters. You give representation, let them take a call because there are rulings which say it should be with the date of entry into service only. All right?
Yes.
In all these matters, the essential grievance of the petitioner is that this date of regularization ought to have been effective from the date of entry into service. First, the counsel for the petitioner submits that the very idea of regularization is to regularize the past service. And that having not happened, the interference of this court is warranted. Next paragraph. Learned AGA appearing for the jurisdictional OPs. And
jurisdictional opposite party is OP 1 and 2.
OPs points out that in the absence of a representation, approaching the writ court directly is not desirable in as much as that would only increase pendency level of the court proceedings for cases. Personally. Therefore, he suggests that petitioner should make an appropriate representation to OP numbers 1 and 2. And the direction may be issued to consider the same. Personally, this appears to be sensible. Next paragraph. In the above circumstances, petition is disposed of, giving liberty to the petitioners to make appropriate representation, seeking alteration of effective date of regularization of their services within 2 weeks. And if such a representation is given, the decision will be taken by OP numbers 1 and 2 on the same within an outer limit of 8 weeks. In accordance with first, all contentions in that connection are kept open. First, it is open to OP numbers 1 and 2 to solicit any information document from the side of petitioners as are required for due consideration of the president. Web copy to be acted upon. Registry to send a copy of this order to by speed post to OP numbers 1 and 2 for compliance. Okay. This photo. All cases, please.
Item 13. Petitioner engaged on 2018 lordship and he became in PUT lordship in SCST department, and 2023 he became the regularized lordship.
Arrears of salary not given.
Lordship,
differential of salary is not.
Differential means grade pay should be not 2200 as per the Niranjan Nayak case, it should be 22,800. There is annexure 7 your lordship at page 26.
2,800.
Yes. 2,800 is the grade pay, but they are paying me to 2,200.
In similar matters, what
annexure 7 lordship, the judgment is there.
Niranjan Nayak judgment.
Niranjan Nayak has been followed in Rajiv Kumar Sahu, And the Rajikar Sahu also contemplated at page 29.
Where is your representation?
Lordship, representation is given to the OP number 4 and OP number 4 annexer 8 at page 30. He has sent it to the OP number 2. Annexer 8 at page 30. He has said that we have asked for that our grade pay should be 2,800. As per the other districts, they are also availing the 2,800. For that, he has sent it. Annexer 8 page 30.
No decision is taken on the representation.
No, he has not filed a representation. That is annexer 8 is the recommendation of the.
No, that your officer has referred to his representation.
Yes.
So that copy is not furnished. The officer has sent it to OP number 2. OP number 2 has to take the decision.
Lordship can disclose directly.
Right down.
Take it.
Petitioner has structured his prayer as under. First off, essentially, the grievance is as to what should be the grade paid. First off, learned counsel submits that the grade pay has to be rupees 2,800, whereas what has been given to his client is only rupees 2,200. 2,200. And that this is contrary to certain decisions of coordinate bench of this court. One such decision being WPC number 13112 of 2021 between Rajiv Kumar Sahu versus State of Odisha and others, disposed of by a coordinate bench on 19 February 2020. He also draws attention of the court.
Next page, page 29.
Another judgment.
And that is that order has been complied. Contempt, in contempt.
He tells that in respect of similarly circumstanced employees, the benefit of this judgment has been extended and that stepmotherly attitude is shown for the petitioner. First time. Next paragraph. Learned AGA on request appearing for the OPs submits that he would instruct OP number 2 to look into the grievance of the petitioner as has been reflected in OP number 3's letter to OP number 2.
OP number 4 letter to
OP number 4's letter dated
24/8/2023.
24/8/2023. At Annexer 8.
Letter
Address
number
to OP number 2.
Letter number 2381.
Address to OP number 2. First one. Next paragraph. In the above circumstances, petition is disposed of. Time for compliance is 8 weeks. First one. OP number 2 to inform result of consideration to the petitioner in writing within the said period. First one. Open to solicit. Now no cost. Direct web post copy to be acted upon.
Letter number 14. Number 14, I paid for Passover money.
Passover? What is this matter about? Just tell a few words.
Matter is, my lord, the OP number, I have given a representation before the OP number 3 regarding acquisition, illegal acquisition of my plot to make construction of a electricity tower. That's why they have
that representation is pending.
Your representation is for
stop acquiring my land. They have what they have done. They have illegally, without any notification, without following due process of law,
taking your land.
Yes, your lords.
Who?
Electricity department. OP number 2.
OP number 2.
My lord. Sorry, OP number 3.
The right to property is a constitutional guarantee under 300 capital A. How can you barge into private property?
That's why he has filed.
They have.
What is the representation of fundamental rights? Only petition. No question of representation.
OP2 is a private party.
OP2 is a private party.
No, my lord. OPTCL.
That's a
Odisha Power Transmission
corporation.
Corporation is a state under Article 12. Sukadev Singh versus Bhagat Ram.
So for that, he has filed before the collector the representation.
What will happen to representation? How anybody can barge into his private property?
They have declared a notification. My adjacent plot.
They have a procedure under Telegraph Act, na? To take private land for the purpose of electricity, wire laying, pole fixing, etc.
Collector is the district head, and the collector will examine and verify whether that is not.
You can't barge into the land of the private.
Even if collector order is there, there is no mention of my land. There is a mention of my adjacent land, but they have illegally
issue emergent notice. Learned DG is requested to accept notice for OP numbers
1 to 5 except 2.
Except 2.
One is state.
3, 4, 5.
Yes.
First up, emergent notice to OP number 2. First up, OP number 2 is restrained from interfering with the property of the petitioner till next date of hearing. Or, why pass over? You argued so well. Yes. Next.
Item 15.
That is all petition is private school level 5 capital A. Now pursuant to the advertisement for the engagement to the post of CRC Annexure 1 page 10, advertisement was issued for engagement for the post of CRC on deployment basis. So as per the
how long you have been working?
Continuing since 2006.
2006.
Yes, friends. Now your lordship.
Where have you stated? You are working since 2006.
Your lordship. My appointment 2000 Annexure 2, page 16. And pursuant to the advertisement, he had applied. He applied for all the documents with the particulars as in due time before 25/7/2025. But is applicant before the OP number 6. BO or some
emergent notice. Under the recruitment process in question, comma, one post shall be kept vacant. First one. Yes. Web copy to me, please. Next.
Second one also same.
Same.
Yes.
Same.
To allow them to participate in the selection process.
It is open to the petitioner to participate in the recruitment process.
As per the advertisement.
In terms of the advertisement, without prejudice to their rights in the petition.
Yes.
Okay. Permit them. They have been working since 2006, 19 years. Yes.
Item 17.
Subject to other compliance.
In this petition, my lord, petitioner challenged the order dated 21/3/2025 passed by the opposite party number 2, my lord. The fact is, my lord, petitioner is challenged in the second round litigation. In first round, petitioner challenged the illegal selection of the opposite party in the cook cum helper, my lord. Honorable Court direct to the opposite party number 2 to consider the matter and issue notice to the present petitioner and pass a order. But without issue any notice, opposite party number 2 pass a order without following any decision of the Honorable Court as well as the writ petition and representation of the petitioner, my lord. My lord, in this case, my lord, the Honorable Court very clear stated that the notary divorce and notary marriage is not a valid marriage, not a valid divorce, my lord. But in this case, my lord, during selection time,
the opposite party number 4, who is selected in the cook-cum helper, is not produced any document. After selection, 5 days of selection, he produced and they are selected. And when I got RTI from the authority, opposite party number 2 office, then I see that at the time of my lord selection procedure, he is not produce any divorce certificate. If the opposite party number 2 produce the divorce certificate, which is also be illegal, because as per the decision of the Hon'Ble High Court,
There is no divorce decree.
no, you only a notary divorce. Mutually notary. Notary. My lord, I have cited Agnes decision Annex 9. In Annex 9, page 65. In this decision, Hon'Ble Court, 2025-62 OCR, my lord, in this decision, my lord, Hon'Ble Court stated that
You take notice.
Yes.
Take issue emergent notice. Mr. Lenka accepts notice for the notice, emergent notice to private party.
Private or 4, my lord.
Copy number 4. Returnable within 4 weeks.
Main is a government party is 2, 3 and 5. The school headmaster and the ABO is the main
3 and 5.
1, 2,
3, 5.
5.
And
But
4 will be private party.
for which purpose? The culprit is my lord in this case, my lord.
4 and 6. 4 and 6.
The managing committee.
Yes, sir.
Next.
Next one, number 18.
May I please alert?
Last email, that is the case. That the BEO didn't respond to the AGS instruction. I am filing the counter today. All those documents he has asked for.
Copy.
After,
You give copies.
yes, I have.
Otherwise, how he should file his
Today, yes. Yeah, I should.
take that. Enquiry is on now.
Yes, Your Lord.
Enquiry is on.
No, inquiry,
Yes, Annexure 5.
he was asked to submit the written statement of defense. And in the meantime, he approached this, Your Lordship, that some documents have not been supplied. That is the situation.
With this document, he will prepare written statements or objection. You give him reasonable time. Thereafter, based upon what he says, you take a decision. Okay?
Yes, Your Lordship can dispose of this.
That's what. Otherwise, how he will be able to file his written statement?
Yes.
Okay. Shorn of the text of the prayer, learned counsel for the petitioner submitted that his client will not be in a position to take effective defense in the contemplated disciplinary inquiry in the absence of relevant copies of documents. First off, he also tells that if all the copies are given and a reasonable time is afforded, he is trying to prepare his defense statement in the inquiry in question. And that would satisfy him. First off. Next paragraph. Learned AGA, who had taken time other day, has handed a set of papers to the counsel representing the petitioner. First off, he has also filed a formal statement of objections resisting the petition. First off. Have you seen those documents now?
No.
Whether your client is here?
Just now.
Yes, just look into and we'll dispose of it. He will give 2 weeks time to file objection.
Yes.
Till then, you should not take any coercive action against him.
No, that Your Lordship may see, out of 4 documents, the certificate we could trace down. But his application in the year made in the year 2005, that was that could not be traced down. The application.
What was that application?
That Your Lordship may see the representation letter 11A 2025, Annexure 1 to that report. That we have stated in our complaint.
Page 26, Your Lordship. First, the application submitted by the petitioner so far the recruitment is concerned as per the advertisement, Your Lordship. Along with the application, what certificate, what documents we have submitted, that we have asked for.
Only item 1, the
That is the,
application could not be tested.
Only item 1 is not, 2, 3, 4 are given.
Yes.
2, 3, 4 are given now.
Yes.
He is saying that document is not available.
No.
That document is the
You
base.
accept that contention. If something is not available, how can I direct them to give it? It will be an impossibility.
That is the
And an inquiry in a regular form is held to, no adverse action shall be taken against the petition. First, all contentions are kept in the inquiry. To bless for or web copy to be acted upon. Next. Just refer to Kashinatha Dixitalu versus, which is that judgment for the there is one judgment. Kashinatha Dixitalu versus
Union of India and
India versus Kashinatha Dixitalu.
My lord, Kashinatha versus Union of
Just
India.
give that copy.
My lord.
Yes, okay. Refer to this judgment.
This petitioner is retired assistant teacher of the block and institution, my lord, seeking pension, my lord. Similar matter, your lordship issue notice.
Pension is not given.
No, my lord. The block and institution covered by
is pending.
similar matter, my lord, say posted to 3rd week of September, my lord.
To notice AGA to accept the notice for OPs. Call this matter along with the
I gave in the
WP number so and so.
already given.
Next.
In this case, the petition was challenged the illegal action of the opposite party in not sanctioning third RSCP. Third RSCP in favor of the petitioner.
Similar matters covered
by Ashok Mahapatra.
No, that is
your division bench. No. September 11th.
Yes.
Issue emergency notice. AGA to accept notice for the OPs. Call this matter in the 3rd week of September. 3rd week. Okay. Along with OP, do you have connected OPs now? All right.
Item 21. 21 minute. The order at annexure. Annexure 5, page 23 challenge before lordship.
What is that order 24/7/25?
That is, allotment was cancelled, which was allotted in since 1998 in my favor. A plot of Bhubaneswar Development Authority has been cancelled.
Cancelled.
The allotment was done in the year 1998, Miller. Basing upon circular of 2014, it has been cancelled.
Issue emergency notice. The AGA for
all the parties.
No, development authorities.
You only appear. No, there is panel consent. Issue emergency notice.
For one night, actually.
AGA for one emergency notice to the rest. Status quo till next date of hearing.
Already cancelled. Cancelled.
But your possession will be retained by you.
Yes, sir.
Status quo with regard to possession of the site in question, plot in question.
Obliged.
Till next date of hearing. Yes.
Item number 22.
Well, this is covered by your lordship's judgment in Lokanath Behra's case, but I have given the corrected copy. In all these 3 matters. I have corrected it.
You have corrected all?
Yes, yes.
AG appears for?
AG appears for 1, 2.
Notice may not go to other, sir.
No, not required.
Governing body.
Governing body is not the required.
We will send the registry to send a copy of this order.
Yes, yes.
So OP number 3.
OP number 3.
OP number 3 for consideration of the speed post in all these. Yes.
Item 23.
All the 3 matters are similar.
This is Lokanath.
Good.
23.
23 also same. To see whether the private party is the index copy of it. You have rectified that one?
I have not.
Just make it complete this one. You ask Mr. Swain, he will tell you. Yeah, so that it becomes easy. 23?
24.
24. Yes.
Item 25.
May, please, madam.
Yes.
The petitioner who was appointed as an assistant teacher, my lord, while continuing as such, got 2 promotion, my lord, in his respective time, my lord. But while continuing, my lord, on 30th of January 25, Annex 7, he was suspended, pending framing of charges and trial of departmental proceeding, my lord. Till date, my lord, they have not proceeded any or not, they have not issued any charge, my lord. But
Ajit Singh.
Ajit Chaudhary, my lord.
Ajit Chaudhary.
And moreover, my lord, the recent judgment of the Karnataka High Court also was the order of suspension relying on Ajit Chaudhary that you cannot place without any framing charges. Para 14, my lord.
Because it was rule is like that in
Ajit Roy, sir, Madam, say Ajit, sir, that is in
we will direct them to consider your representation for revocation of this pension.
I will file a representation, madam.
Yes.
Madam.
Perfect.
Ajit Chaudhary, madam, there are 2 documents. One is marked well, that may be seated.
The short grievance of the petitioner is reflected in his prayer. First one. Next paragraph. Learned counsel for the petitioner submits that his client would be giving a representation seeking rescinding of the suspension, which is effective from 30 January 2025 under Rule 12 of OCS CCA Rules 1962. And if a decision is taken, if a direction is given to take a decision on the said representation on a war footing, his client would be satisfied. First one. He also adds that the decision has to be taken in the light of Apex Court decision in which is Ajay Chaudhary.
Here, madam. 2015 Supreme Court.
Ajay Chaudhary versus Union of India.
Madam. Para 14.
Next paragraph. Learned AGA appearing for the OPs in all fairness agrees to instruct his official client to look into the grievance of the petitioner as would be aired in the representation in the making in accordance with law, especially keeping in view the observations of the Apex Court in Ajay Chaudhary Supram. First, this is appreciable. Next one, in those circumstances, petition is disposed of, giving liberty to the petitioner to make the representation within 1 week. And if one is made, the same shall be considered within 3 weeks next following in the light of Ajay Chaudhary. All contentions of just over. Yes. Sit. Next.
Item 26.
Yes.
Before submission, my lord, I make a small prayer. There is a title error.
Where it is?
In course title, that is a yes, headmaster instead of assistant teacher.
Counsel for the petitioner on oral application is permitted to rectify the cost item. I believe of the court he has rectified.
This is a matter relating to release of sanction of incremental dues.
That is Annexure 6 is pending before the opposite party number 4 to opposite party number 3.
Is that representation?
Opposite party number 4. When that is not representation, that is forwarded the incremental dues by the headmaster. So you'll also direct, I file a fresh representation along with that document that will be acted upon within the stipulated time. Your lordship may fix.
Where is your prayer? 9.
Page 9.
Yes. Page 9.
Petitioner has structured his prayer. Next paragraph. Learned counsel for the petitioner submits that if liberty is reserved, his client would be making a representation to the jurisdictional office and a direction being issued to take a call thereon in a time-bound way and in accordance with law. First one. Next one. With the above proposal, learned ASC appearing for the, on request appearing for the OPC is agreeable, provided that all contentions are kept open. First one. With this caveat, learned counsel for the petitioner is agreeable. First one. Next paragraph. In view of the above, petition is accordingly disposed of. The time for compliance is 8 weeks. Once the to be reckoned from the date the representation is made by the petitioner. First, all contentions kept open. Public. And if it is open to copies, which always etc., we have copy to be acted upon no cost. Yeah.
This is for the denial of aerial entitlement based on judgment of Tarsam Singh. Issue have been settled by number of decisions. Recently, your lordships are sitting in writ appeal. Also allowable are 2 cases. I have referred to that matter in the writ petition. WA number 3222 of 2023 and 2854 of 2023.
Arrear entitlements.
Yes.
What is that arrear?
That is, my lord, they have restricted, my lord, granting benefits, my lord. 3 years prior to, my lord.
3 years prior to?
Prior to my entitlement.
Prior to retirement.
Yes. If you also look at the annexure 12, my lord, what they have done, my lord, page 54.
To take notice. Yes, but ASC is requested to accept notice. First of matter lies in a narrow compass. Call this matter in the 3rd week of September.
But I am for 1 and 2 million.
1 and 2. And the
Notice to go for 3.
3 million governing body. Governing body, my lord.
Notice to 3.
Item 28.
The petitioner is a retired broker and employee. Claiming the pensioner pension, similar matter, your lordship has 5th to 3rd week of September.
Issue emergent notice. ASC appears for the office. Any private party?
No, no private. Only government.
Call this matter along with WP number.
I have given the notice.
Next.
29 also same matter.
29 also same.
9.
Yeah.
Item 30.
So this is a case of transfer. Your lordship may kindly turn to annexure 3 at page 14. It starts from page 14. My name finds place at page 15, serial number 16. Manas Ranjan Dhar Mahapatra. He has been transferred from Government Upper Primary School Panisal to Government Upper Primary School Kalabadia on rationalization ground. Your lordship may kindly see the last column. On the ground of rationalization. Well, I challenge this order on 2 grounds. My first ground is he has not completed the retention period of 6 years. Your lordship may kindly turn to annexure 2 at page 13. He came to that school by way of promotion to level 4 of the elementary cadre on 17th October 2022, page 30, serial number 1. He came to Government Upper Primary School Panisal
since he was promoted to the rank of level 4 of elementary cadre.
In the same school?
No, different schools. He was in Pathuri UG UPS school. And he came to Government Upper Primary School, Panisal, by virtue of order under Annexure 2. He has just completed 2 years and 9 months. So retention period is 6 years. That is first ground. And so far as the rationalization ground is concerned, admittedly, he is not the senior most teacher of that institution. And you will also may kindly see the government notification.
It should be senior most member of the teaching staff.
No, senior most teaching staff is to be transferred as per the rationalization principle. That is at page 22. Lord Sabha, kindly see Roman 5. While transferring the surplus teacher from the school, the station seniority would be the basis of effecting transfer of a teacher, and who has maximum stay at a school would be transferred.
That is first come, first go.
Yes. And retention period is Roman 6. The teachers who have completed 6 years of continuous service in one school would be eligible for transfer to another school.
That is eligible for transfer.
Yes, eligible for transfer.
Not that they are liable to be transferred.
Yes, absolutely correct. But here, well, he has just completed 2 years and 9 months in that school, and he is not the station senior teacher.
Is he relieved now?
No,
not relieved.
Not relieved.
Issue emergent notice. Stay of impugned ASC accepts notice for the OPs. Any private party?
No private party. Nobody is coming to my place.
Stay of impugned transfer order so far as petitioner is concerned.
Annexure 3.
At Annexure 3. Till the next date of hearing. First one.
Your Lordship may indicate that I may be allowed to continue.
Petitioner is permitted to continue in the same school.
Prior to his transfer.
Lordship may say, if not relieved. If already not. No, yes, if already not relieved and reported elsewhere. If relieved, he can be taken back.
Yes.
If already not relieved and reported to the transferee.
Yes.
Place. Transferred place.
Transferred place.
Okay.
Item 31.
My please, Lordship. Before I start, Your Lordship, there are some corrections in the prayer portion, if I may permit you to carry
What
that
is
out.
that correction?
Instead of setting aside the order, it should be directing to release. Minor
Leave of the court. Petitioner is granted leave of the court on oral application to rectify the prayer cause. First. Yes.
Your Lordship, the petitioner is a clothing company which imports fabric rolls from various countries. In 2020, one such consignment was coming from China. It came to Chennai. I am based in Noida. I hired a transport company to transport the fabric rolls from Chennai to Noida. 2 trucks were there. One of the trucks, ganja was there. The case was registered. The truck was seized. My fabric rolls were also seized. I filed an application for section 457, which was rejected. I came in criminal revision before this court in the year 2021.
457 is when material is produced before the court.
Yes, Your Lordship.
451 is where it is not produced before the court. It is produced before the court.
Yes. It was produced before the court. I came in criminal revision before this court.
Under which act it is? The seizure and other things.
CRPC, 457 CRPC.
No, ganja and other things have been seized.
20 of narcotics.
Narcotics is
NDPS.
Whether to NDPS section 451, 450.
Yes.
It's an apply.
Yes. The CRPC applies. Now in the criminal revision, this honorable court asked me to furnish bank guarantee. This court observed that I am not an accused. I am not a witness. I have no connection with the transport company. And the fabric rolls were never used to conceal the ganja. They were kept separately in the same truck. But then the court said, you furnish security for the value of the fabric rolls. And upon completion of the trial, you might, the bank guarantee can be discharged. Outcome of the, if it is observed that the fabric rolls were not involved, the bank guarantee can be discharged. Now, Your Lordship, in 2025, the trial has been completed. There were 4 accused. Trial against 3 accused have been completed.
And you were not one of them.
I was never the accused. I was not named in the FIR. One of the accused jumped bail and the trial was split. Now the trial court in his judgment stated that no order with regard to the confiscated materials can be passed since trial has not been concluded against that accused. I am neither related to any of the accused. I am a different company. I had hired the transporters to take my goods from Chennai to Noida. I have been furnishing bank guarantees, renewing it year after year for the last 4 years, Your Lordship. I am only seeking discharge of a bank guarantee. Trials, 3 accused persons have been acquitted. The judgment says the investigation of the police is flawed. Even if the other accused is apprehended, most likely he'll be acquitted. In any case, I have no connections with them.
Order dated 4/12/2020.
Yes, Your Lordship, 2021. This is the order of the High Court.
2020 order, this is a criminal petition.
Criminal revision.
Criminal revision comes by for me.
No, Your Lordship, this is the correct. That was a criminal revision. The second revision is not maintainable. So now I'm.
But for it, you could have filed.
The registry asked me to file a rate, Your Lordship. I inquired about it.
Did
Yes.
But there is one judgment of the.
No, I have seen there are multiple rates earlier filed before this Honorable Court and disposed under similar matters.
Is it?
Yes, Your Lordship.
Take out what Apex Court said in Pepsi Foods.
In Sundar Bhai Desai judgment, Ambala judgment, Ambala. Saying that the confiscated materials should be released during the trial if the vehicles or other things.
So whether writ petition is maintainable.
I will have to check that judgment, Your Lordship, but I inquired from the registry and I have.
Take out.
Which one?
1996 or 98, page 120. Pepsi Foods versus. So it's just look into 96 or 98. 96 Supreme Court 122. Pepsi Cola or Pepsi Food, something like that. That was a special.
97, Your Lordship. 97.
AR 1996 SC 120.
Pepsi Foods was a special judicial magistrate.
Just see that what they said. Will you look into that and come back next week?
I can do that, sir. Maybe any time this week.
Okay. So this week we have difficulty. Many matters we have loaded to the calendar.
I will come back with this. Let the opposite party take instructions in the meantime.
Yeah, you take.
Yes, ma'am.
The ASC is requested to accept notice. Yes.
Published.
Week up to next. Yes.
Also, I may be permitted to make the changes.
Yes, you are permitted. Use the. But where you have to make it online or?
For hard copy.
Next.
For orders, item number 32.
I have filed a petition to withdraw the evidence.
Withdraw?
Right.
Why you not happy with the court?
But they have already compared my prayer, and I have what I pray.
Counsel for the petitioner submits that petition may be disposed of as having been withdrawn. First of all.
With a liberty to file application.
Liberty to file fresh one.
No, if any future cause of action arises.
Liberty to agitate on fresh cause of action. First, next one. Order according and WPH this notice.
For admission, item number 33.
Yes.
Rendered on behalf of Mrs. Malik, I will pass over the action.
Your wife is weak.
She is in a late.
She's asking for passover.
Yeah.
Lordship may call it any other day. Next week. Next week.
Today?
Not today. Next week.
Okay. Good. Accept the request of.
Item number 34.
Yeah.
My lord, on behalf of Mr. Bivera, I pray for adjournment, my lord.
2019 matter.
34, my lords. The rest for adjournment, pleadings are ready. So I was suffering throat sore, my lord.
2 weeks at the request of. What is Mr. Counsel, neither AD nor undelivered letter received from OP7.
My lord, I am a proxy counsel, my lord.
OP7, who is OP7?
OP7,
P7 is,
No, P7.
no, P7 is not there. 1, 2, 3 and
1, 2, 3 minutes. 1, 2, 3.
All right, on health ground of arguing counsel on this matter.
P7 in item number 33. Now is placing for 34. P7 in item number 33 earlier matter.
Health ground of arguing counsel for petition. Next.
Item number 35.
35. Mr. Counsel, do you want water?
No, my son, that stove from my
35, my lord. I am to the petitioner, my lord, and today I am filing the rejoinder as per counter dated 22 2000.
No objections. I am for the.
I am serving copy.
I have already filed counter since 2024. The whole difficulty is the road has been closed and there is no passage to approach my plot and my half constructed building is my there, my lord. He lost in the courts.
The road.
Wait a minute.
I have already served a copy and also served a.
Even if I will not rely upon the judgment, rejoinder, my lord.
You don't want to rely upon?
No, I will not rely upon.
Court may rely upon.
My lord?
Court may rely upon.
Yeah, also may rely upon. But fact remains, what difficulty the present opposite party is facing.
Can it tomorrow?
It can it tomorrow. Yes, tomorrow.
Can we look in?
Tomorrow can it be on fresh admission, my lord? Can it be on fresh admission?
How? Can we put the clock anti-clockwise? If you do too much clock, I will be very happy.
It may be taken up next week because if she is filing the rejoinder, I have to go through it and I have also taken instruction from my client. My client is the original client, the OTA court who has passed the order and also is carrying out the order. Now the question is that the road is there. That road is under encroachment under this.
That would is purely my
encroachment of
this
submission. I'm sorry.
That is his submission. If I say it, you may raise your voice. If he says it, you have to tolerate it.
Yeah, the sufferer is my client, madam. Due to blockage of the road has been blocked, and that the road is maintained by the BMC, and the road has been blocked. The commissioner has asked him to produce the cell deed, what we have recorded in his name. He couldn't produce the cell deed. The commissioner's order is there, my lord. And thorough inquiry has been conducted not once. Twice inquiry has been conducted. The petitioner was present and detailed order of 17 pages were passed by the OTA court, my lord. The lordship kindly see, two persons who have blocked the road. One has already removed that passage because the case has not been initiated after removal. And another, the petitioner is here. He has blocked the road which has been developed by the, and 15 feet, here, when the plan was approved, 15-foot road was there. Now the inquiry report has come out, 7 foot 6 inch road is there, my lord. The lordship kindly visualize the problem of mine, my lord. I am unable to approach my road when the half construction building is there. That is my predicament.
May I submit, my lord? May I submit to submit?
PMC already filed 3 and 4. They have filed the counter. So the number 4 is the private party who is being affected.
You are.
I am for the BMC.
He is the corporation, madam. I am the private.
BMC held in his favor.
Not in my favor. BMC has held the encroachment is there, madam.
There is
the encroachment is there and direction was given for encroachment. Against that, he has prepared
the order of status called demolition.
Against that, he has prepared the appeal. Appeal was also dismissed. Then he came up in the writ petition. And now it is in the second round before my lord for a consideration whether how longer it can be.
Appeal was dismissed only on the ground that I could not take any step to file the written version. But on date, if your lordship see annexure 10, page number 59, my lord, 59 to 60.
You have blocked a public road.
No, that is purely my private plot. If your lordship see page number 22, that is.
How you acquired that plot?
My lord, that I have purchased. And I am
yes, that is the point.
And I go produce. You don't.
Can see my counter? The order of the commissioner.
And my question, you are found out by the inquiry. She has a purchased plot against
and the arrow is purely
affected her house. But with regard to the plot that is the road indicated as road,
he has no right.
that our stance is in our favor, but without any salary.
My lord,
that salary was asked for, that you produce it. If you have a salary, then you produce
property.
that I'll produce in the next year.
Petitioner to produce sale deed in respect of alleged encroached portion of the property. Filling
and so person on road.
That is plot number 991 people 4.
Road
No, sir, plot number.
Filling which adverse inference would be drawn against petitioner, respondent. Petition. And petition may itself may be dismissed. Yes. Call this matter on 15th.
My lord, may the letter of that, my lord, to produce the sale deed.
Next.
Nice.
A copy of the rejoinder be also served on me.
Oh, my lord, just now I'll serve it. In course of it, I'll serve because I have.
File rejoinder anyway. You have
also serve to state and opposite.
File it in the registry.
Oh, my lord, oblige.
Instance, my lords, National Development Authority, there, my lords, there is a direction to give possession to them. Process is going on.
You want to take rest or make an order to take rest?
Rest, my lords. I pray, my lords, do not mention. So process is going on, my lords. That possession will be given, I think, within a day or 2 months.
Is it?
That's why
with that we can dispose of the matter.
But let it lie over, my lords. So we'll
lie over. It will be better. Let it come on next week. In the meantime, I will also take
next.
Let's see.
Item number 37.
It appears in Ganesh festival you have eaten more ghee.
That's not the thing.
And without sharing it with the dead.
Yeah, my lords, a small prayer. My lords, some other items, my lords, a second list.
No.
Once my friend will be there.
Just keep your yes.
Item number 37.
37. Nobody.
Item number 37.
Any relief can be granted in the absence of the petitioner. Cannot
because counter is there, my lord. It is challenging the construction.
2 weeks to enable council.
Counter has been filed. Readings are complete.
Next.
Item number 38.
Yes, sir.
The matter, my lord, pertaining to declaration of result. Well, they declared the first semester, they have not declared, but they have come up in counter that they have declared the result on 3rd February, then even assuming that is true, that is even after 1 year from the examination appears. But my humble submission, if 3rd February of in the document showing the declaration results done, then 3 documents which I have filed in my read petition and in my affidavit, that it is belies the counter that they declared the result. They have not declared the result.
Physics 1 first semester.
First semester. In counter they say, you have declared the result on 3rd February 2025. It is 1 year after.
1 year after.
My lords, we have published the result. Your lordship will kindly come to page 6 of my counter and next year B/5. And all the candidates have failed.
Failed.
My lords. The
He
failed result
also has failed.
My lords, the failed result from the tabulation register is here before.
This is
your
not
lordship.
mode of.
No, it's a university, na?
University, they have not informed to the college, not to the student.
No, it is there, na? It is there is result.
No, they have not published the result below. This is a statistic you have to tell. This is not the.
How results are published?
Yes.
Perhaps a university registrar have called him now.
Sorry, my yes. I apologize.
No problem. Such things happen now. Yes, you have not published the result.
No. What he states, I am a bit
unwilling.
I don't agree with, because the document that I have filed, I cannot file that document before your lordship. I cannot dare to do that also, because B/4. B/5 is the result published, and that tabulation register copy that I have passed on to your lordship states that these students have all failed and they have been given a chance to appear in the next examination without the fees altogether. Looking at the point that the result has been delayed, the university controller has taken into account that part and has asked these students to appear, fill up forms without the fees. That also they have not agreed to. And now your lordship may kindly look at the prayer of the petitioner in the petition. It's publication of the result, and result has been published, so it becomes infructuous. That is my submission.
My humble submission, I deny, refutes the statement. The result has never been declared. By lordship can attend to page 22, annexure 2. That is the college in which
they have produced it.
They have produced of late, my lord.
There is a delay in publication.
1 year, more than a year.
For that, what should be done?
My humble submission.
You will be permitted to take up the examination free of cost.
Right to revaluation, with right to revaluation, because had the student been apprised of, they could have made application for revaluation. That right to revaluation, yes, I understand.
Right to revaluation is there.
Yes.
No, that's for a particular period.
And
So
then,
now that
Without public, that arises from the date of publication.
no, that is fine. Your lordship, I cannot stand in your lordship's way to.
What I suggest is, you permit them to apply for revaluation.
yes.
Okay. In the event they pass, no question of holding examination. But if they fail, then they are bound to appear for the exam. Because there is fault on the part of the university.
Yes.
I don't disagree with your lordship's view, but question
holistic approach.
But the question is when that particular document produced before your lordship states that they have failed. So question of that.
Therefore, they want to apply for revaluation.
Yes.
Yes. Your lordship.
You have declared result when?
We have declared
According to
result.
3rd February. According to
3rd February.
But it's according to me, it's the imaginary date.
Did you send a copy of the result sheet to the college?
To college. It has been, I have stated that.
How it was sent? Who took that?
Yes.
Which peon carried the file?
My lord, the college principal.
College principal says it has not been sent.
Yes, we are page 22. That college principal on 24th February, that is when after 3rd February, wrote letter that not declared. You got it, the principal says so.
What principal says?
Yes, my lord.
24 February.
Yes. 24 February. That is to the 3rd February. Yes, the para 2, my lord. Paragraph 2.
In the university website under heading.
Check 2. More of it. What process? This is the state of affairs on 24 February. How come then 3rd February?
It has not been sent to the university yet. So, in fact, the principal is saying,
yes.
Principal has kindly come to para 2B.
Yes, yes.
Result not processed, kindly wait for the result to process. In fact, when George Bernard Shaw came to Bombay for convocation ceremony, he said, Bombay University is known for the height of its tower and the depth of its ignorance.
Yes, the pinnacle of the knowledge.
Both the things are bit opposite to each other.
Dramatically.
Maybe very high.
Yes.
Very high tower, like your mobile towers.
There's a nice saying in Orissa, Dippo Todo Andhar.
Shadow under the
lamp.
So that particular part, in fact, he has filed an affidavit thereafter as regards that statement of the principal, to which I have not got any instructions, my lords. I have sought for
you suggest now you assume that they are your children.
My lords.
As a parent, what you would have done? Do it to them.
In all fitness of things, with all fairness, They should be given a chance
and apply for revaluation.
Yes.
And in the event the results are intact, it appears they will be intact only, going by their performance.
Intact in this manner.
That's very true.
In this manner.
Then they should be permitted to take fresh examination.
But in that case, the timings of the examination.
I will fix that now. Yes. But it should not collide with regular timings and other things.
In that case, what I would humbly suggest is your lordship may say, looking at the peculiar facts and circumstances of the case.
Yes. Without making it a precedent.
Yes. Without treating it as a precedent.
Can we say that that both of you broadly agreed with the suggestion of this court? For you, there is difficulty.
There could be, sir. No. Or in the alternate, if your lordship permits me, I can take instruction. Let this matter come tomorrow. I'll be talking to the
come tomorrow. If you agree with that,
ventilating your lordship's mind.
Because students should not lose their right to revaluation, regardless of what will happen.
Yes.
It's another thing. It's a right. There is one famous judgment of English court, which were taught in law of torts, where he wanted to vote, but he was refused voting right. Then in cross-examination, he admitted, I wanted to vote to the candidate who has won in the election. Then court asked, how you are aggrieved? I am aggrieved because my right to vote is cut short. I forgot its name. Ashby versus White. The injuria sine damnum. The very famous judgment. Right is so important.
But your lordship is aware of the landmark judgment on revaluation. Board Maharashtra State Board versus Kumar Seth, 1984 Supreme Court.
Correct. 84 Supreme Court. There is another judgment of Ghanshyam Das versus Swains, earlier to Maharashtra. In that one. But our High Court took some that Anjali Bansal versus Bangalore University. Little different view they took, Justice Mohan. Anyway, let us see. Just look into that Ashby versus White tomorrow. You have to
your lordship may, for my convenience, your lordship may call it day after tomorrow.
Yeah.
Beg your pardon, your lordship. Lordship, item number 24 of the second weekly list. Lordship, it was mentioned earlier, your lordship. There is an interim order to.
Wherever there is.
My like 35. I beg your pardon. 35 also interim order continue to next date. My like 35.
Till next day.
Maybe small check. Did you mention item number 7 of the quiz that next weekly list? And they have taken time without a consent, my lords.
Therefore, what action? If a complaint against the bar.
No, my lords. Exactly the more than 6,000 posts of the teachers has been stayed due to this process, and is like 5 months delay has been done.
What date they have taken?
2 weeks after, my lords. Let it come tomorrow, my lords. And our IA is pending for intervention.
Next week we'll have that. Let us do that.
Date
item number
7, my lord.
7.
Date will be fixed, my lords.
But she's already translated. Anyway, we'll rectify that. Wait.
My lords.
Yeah.
Bless me.
This friend what will give it back to me. Well. Yes.
Two 37. I was held up in some other court number 3. May pay the pleadings are completed, counter region or the only 5 written note only given. Reasons will given. May pay next week any matter.
After 2 weeks.
Because construction of
Adjourned by 2 weeks. It is adjourned by 2 weeks.
Let's keep it next week any matter.
But it's already very.
You also kindly consider because the construction of bus terminal over Gochar land is going on.
Yes.
Or
yes.
Yeah. Item number 39.
39, well.
Yeah.
Lordship, see the last order, 12-8 order. Lordship has directed the state government to file response.
Yes, my lord, we will file our response, my lord.
One
But, sir,
event to a
allocated to
particular
public-
project has been diverted.
Diverted. Ah. Yes,
4 weeks time we are now.
4 weeks.
Right.
You have interim order now.
Yes.
Call after 4 weeks, interim order to continue.
Item number 48.
My lord. Item, I have a case, my lord, in 34, item 34 in weekly list, my lord.
24.
Yes, in the second list, my lord. I want next week, whether some development has taken place in the meantime, my lord.
34, who appears for other side?
My other side, Mr. Tripathi is appear. I'll inform him.
Inform him.
Yes, sir.
Call after 2 weeks. That's the request.
Obliged.
Yes.
Item number 40, I am appearing for opposite party number 3, who is the principal of the college and also the secretary of the governing body. For which time is given 5 times.
If I will not a synergy happen in this matter, then perhaps it will be lordship. If matter can be real lordship, lordship can receive lordship's last data. Yeah, lordship.
Today, I just got the notice.
Your instruction.
I'll file counter.
Not required. Your instruction will suffice to. But I have a grievance. But I have filed a mistake. I have a grievance.
April 2025.
Lordship. Till next date of hearing, no appointment oblique engagement order shall be issued to any of the any candidate in respect of the position oblique post to which the petitioner was engaged as the mentioned above. Lordship, the date itself, Lordship, Lord and Government Advocate made a telephone to him, her Lordship. Don't proceed with the appointment because there is a court order. And not easy question also. How can we, because we have not communicated with the court order. She confirmed her. No, we are there. Our officers have reported there is interim order. Don't comply. Don't give her appointment. And then, Lordship, we sent a lawyer notice and the person concerned.
Now what happened?
Lordship, they have engaged, Lordship.
You have engaged.
Engaged, Lordship.
Be subject to this.
They file a contempt. Let them file solve the copy.
If you
I'll satisfy the court. Take instruction on this matter. I don't have any instruction.
when we are before court, Lordship, there is a direction knowing.
Yes, I know.
You are flouting a Lordship.
My lord, as per, I have taken certain instruction, my lord. The order was passed on 18th. And the interview was conducted on 6/8. And this petitioner, she stood third. The person who stood first, she got the appointment. And accordingly, appointment letter was also issued.
No, when order is there, why did you issue?
By that time, there was no order.
When it was issued?
It was, order was passed on 18th. And that was communicated to me on 19th. I got the same on 28th. But the CS joined prior to that. As per the, after interview, my lord. I've got that letter, we have received on 20th. And that was sent on 19th. Order was passed on 18th. By that time she had joined.
No. Order was.
My lord, this is it.
Issued on which?
19th August.
19th August.
Yes, my lord.
But by that time, order was already there.
Well, I had no chance to know about the order, unless I get the order. They sent the order in a letter, which I got on 19th, 20th.
Even then.
Prior to that, she has already appointed.
It may not be a contempt.
My lord.
But appointment has to be.
But prior to that, she has appointed.
That is what the apex court has.
Yes, as your lordship directs, but I will file my counter to that effect only. Let them serve a copy of that contempt petition or a petition, my lord. Whatever they have filed. I will give a instruction.
Straightway we take action. No,
I am not on the way, my lord. I am not on the way. If they do apology, I am not on the way. But this is the actual affairs, my lord. Prior to appointment, she stood first. And the person who stood first in the interview, she got the job. And immediately the appointment letter was issued on 14th itself. And order was passed on 18th. And I got the order on 20th, which they served on 19th. I've got that copy also, my lord. They have given me the copy. When they sent,
you file appropriate application. I have to write.
Let them serve a copy.
Lordship, I have filed Lordship for that is both in contempt and and Lordship interim application, that is 15091 Lordship.
No, then solve a copy, my lord, I will answer.
You give copy to 15090.
15090 and contempt number 4110 Lordship, two applications.
You serve copy on the other thing.
I have appeared for opposition, so I have filed vacality in court. 4 weeks to file counter, my lord.
Not 4 weeks. Under
counter, I will file.
1 week will be given. If you want to file. Otherwise, we'll do whatever we want.
As your lordship.
Solve this matter. The council for the petitioner has moved IA numbers.
IA numbers Lordship 15090 Lordship.
15090 of 2025.
And 15091 both Lordship.
We are seeking the contempt
Contempt number.
copy number.
Contempt number.
I am appeal number 3. I am the principal and secretary of the governing body.
Copy number 3.
91 copy of the
It seems alleging violation of interim order dated 18/8/2025. First, learned counsel Sri Crime Suit appears for copy number 3 and 6. Some time to file the counter. First, under the extant rules, counter has to be filed within 1 week from the date of receipt of notice of the court. First, however, taking lenient view of the matter, another week is granted for filing also. First, failing which right to file one stands forfeited, and contents of subject applications will be taken with face value. First, call this matter on
September.
September. Today date 8. Today is 8. Yeah, 8. We are calling it on 16. 16.
Let's increment to
Increment to continue.
Weekly list. Order item number 1.
Yeah.
Can I pray for a short Passover?
Passover.
Short Passover.
Ah.
He's on legs in another courtroom.
Passover will give you, but no adjournment.
No adjournment.
Yes.
Just minutes.
Item number 2.
Kindly pass over. My senior is coming.
Yes. Yeah.
Item number 3.
May I please, my lords?
Yes, sir.
The petitioner joined in service in 1990, 2590. He retired in the meantime on 31st March 2018, my lord. On 31st May 2018. But
he joined on?
He joined on 10/5/90 as a Jogo lecturer in Jogo.
10/5/90.
My lord.
After selection process?
No. Appointment order issued by the principal.
Issued on 10/5/90. Annexed?
Annexed 1, my lord.
As the lecturer?
Lecturer in Jogo.
In yoga?
Yoga. He continued in the post. As per the yardstick, he is also annexed 3 entitled. He approached my lord earlier, this on court. For release of salary for the post of the duty pay. This one was directed to consider the grievance petition, that is my lord, annexure 6, page 28. And operating part is annexure 6, page 28. Operating page 30.
You were working lecturer till what period?
Till my retired superannuation, 31st May 2018. But nothing has been paid to me, despite submission of bill by the principal
opposite point 1 and 2, they refused to pay only on the plea that port was not accepted.
What was not up?
Not up. But I discharged my duty, some bill submitted by the principal to the tune of 18 lakhs something, but till then nothing is paid to me. I retired since 18, madam.
Without regularization.
And no payment. I have filed, in the meantime, I am suffering from different ailment and now bedridden, total bedridden. I have filed the bill submitted in the year 2018. After my superannuation, principal submitted all the bills to the director. That is answer 1 to my miscase. That till then nothing is paid to me.
Who appears for the
Government.
Government. He has worked from 10/5/1990 to 31/5/2018. That is,
if the post has not been approved, then he cannot get the salary.
No, how many years he has worked?
And for approval, he has to approve the state education term.
It is a government college. That's my friend has not. It's a government college.
Even for government college also?
It's a government college.
No.
Only private college?
Only aided college. Only aided college, my lord.
Then why?
I stand correct.
Yes. In the government college, you took his services for 28 years. And now you don't want to pay anything. Which judgment says where a person has worked for so many years, he is entitled to terminal benefits? There is one such judgment. Huh? Can anybody tell it?
Latest judgment, Dharam Singh. Latest judgment. Dharam Singh case, my lord, 31st August. Before that, my lord, the Shripad case. Shripad case also, after directed to reinstate and regularization. And also give pension. Jago regulation. Shripad for regulation and release of pension.
Shripad. Do you have that copy?
Just not me. Tomorrow I will give my lord. I will give both the judgments. I will with me, but not. But not.
Madam has a copy, ready copy now.
Judgment.
So you take copy and give.
I have that with me, but
give copy. Taken free copy now.
Dating for obstacle, but it's highly just my mind.
Earlier also you were before the court?
Yes, annexure 6. Twice I was before my lords.
Twice. Earlier one was WP, WPC.
WPC 10019 of 2003, my lord.
For regularization.
And release of salary, both there.
What happened to that?
They are also directed to consider. They have.
That was decided on.
That was one decided on 31/2003, my lord. Page 830.
Another WP.
Another WP, my lord. Again, my lord. That is
13751 by 2020.
13751
2020
by 2022.
In that, what is that prayer for?
Dispose about
that annexure 13, page 48. Also same prayer to content proceeding. They have passed order. They are approved, my lord. My director consider they have annexure 14. They have rejected. Page 50. They have rejected my claim.
1 second. This WP was decided on.
Doctor decided, my lord, on
13791.
Yes, by one. That was decided on 2011-2020. 2011-2020.
The dispose upon 13/7/2020.
Yes.
13751 dispose upon 13/7/2020.
And you have rejected the order on which day?
That is my annexure
523.
Annexure 14, page 50.
After his retirement?
Yes, my lord.
9/5/2023.
Yes.
On what ground?
Only ground that not eligible.
You are a part-time people, yoga people.
Part-time.
petitioner was engaged as a part-time lecturer in a yoga.
Part-time means how many hours? Where is this for the commission?
Yeah, Annex 14. So Lordship may can see Annex 14. First,
You are on a part-time basis.
At time I have entered the salary remuneration for the period. Discharge duty, my entire pair is to release my remuneration. I have discharged your duty in the college, taken classes regularly, retired after 28 years, salary been submitted by the principal. He cannot reject my entitlement, duty pay. But I say, my can say duty pay. I have not paid for a pension or anything. I only pay my duty pay be released.
yes, if it is not released, then
No, how many times he should come to the court? Only liars will become rich, provided he pays fees to them.
pass this, your Lordship pass this order and
No objections are filed.
No objection, no something. Despite several adjournment, no.
there are no posts that has been received.
Now taken work,
Part-time lecturer.
then that will be violative of Article 23. Which is that judgment? State of Rajasthan versus High Court of Rajasthan. Sorry, State of Gujarat versus High Court of Rajasthan, High Court of Gujarat. 96 or 97 Supreme Court. No person can be made to work without payment. Even serving convicts should make payment. Should be made payment. Can anybody take out that judgment? '96 or 97 Supreme Court. Nobody knows about that. Can you Google State of Gujarat versus High Court of Gujarat? '97 Supreme Court.
The lack of case of State of Gujarat versus High Court of Gujarat, 1998, addressed the issue of paying wages to prisoners for their labor. The Supreme Court upheld the High Court's ruling that prisoners performing rigorous imprisonment labor should
Correct. Even prisoners should be paid. Why not a free man? Right now. Petitioner, the services of the petitioner were engaged by OP number?
OP number 3, my lord. 4, my lord.
OP number 4,
my lord.
As a lecturer to teach and instruct in the yoga on part-time basis. While order dated 9/5/2023, a copy whereof avails at Annexure A14. First one.
My lord. Joined 90, my lord. Annexure for the rejection order.
Sorry, rejection order.
Mine.
Okay, 10/5/1990.
Mine.
While the order dated 10/5/1990 at Annexure A1. And he relentlessly worked as such till 31/5/2018 and demitted office on attaining the age of superannuation. First one. He is grieving before the writ board for non-payment of remuneration admissible to the work in question on a normative basis. For all these years?
All these years, my lord. Entire bill has been submitted by the principal. That is Annexure 8 to my miscase, my lord. I have heard.
All these years.
Annexure 17.
First one. Next one. Learned counsel for the petitioner subjects that extracting work from a citizen without payment of remuneration for almost about 3 decades is a gross violation of the doctrine against beggar enacted in Article 23 of the Constitution of India. In support of his contention, he presses into service the court decision in the state of Gujarat versus Hon'Ble High Court of Gujarat, AR 1996 or 97, but 98? 98, madam. AR 1998 Supreme Court, 1998 2ACC
799.
799. First one. He also brings to the notice of court that he was before this court twice, one in WPC 10019/2003 and another in 2003, decided on 31/10/2023, and another in WPC 13751 of 2020, disposed of on 13/7/2020, wherein he had sought for an order for regularization of his services. First one, the authority concerned by the order dated 9/5/2023 has rejected case of the petition. First, next paragraph. Learned AGA appearing for the official office vehemently resists the petition, contending that the petitioner was working his true semicolon. However, it was a part-time job, and that there was no post against which he was appointed. That being the position, working against no post would not oblige payment of remuneration. First time. So contending, he seeks dismissal of the petition. Next paragraph. Having heard learned counsel for the parties and having perused the petition papers, this court is inclined to grant an indulgence in the matter as under and for the following chance. A. It is not in dispute that during the period between 10/5/1990 and 31/5/2018, petitioner had worked as a lecturer, part-time lecturer in yoga and discharged his duties. First, whether there was a post or not, pales into insignificance once the work is extracted from a citizen. First one. Article 23(1) enacts the doctrine against beggar, which prohibits extraction of work sans payment of wages. First, this view gains support from the decision in the state of Gujarat, Supra. First one. Sirwai, in his constitutional law, law of constitution, or constitutional law of India, 4th edition, describes beggar as under. Next paragraph. Learned counsel for the petitioner is right in telling the court that the official OPs are not justified in not paying the remuneration for the work done by his client for about 28 years. First of all, regularization is concerned, comma, in the absence of the post and full-time work, comma, ordinarily prayer may not be granted. First of all. However, denial of regularization is one thing, and refusal to pay for the work done is another. First of all, it is the latter which Constitution proscribes vide Article 23. First of all. Next paragraph. Twice the petitioner was before this court, vide WPC 10019 of 2003, disposed of by a coordinate bench of this court on 31/10/2003, directing consideration of the case for regularization. First, that did not yield any result. He had filed WP 13751 of 2020, which another coordinate bench disposed of on 13/7/2020, almost with a similar direction. First, it is pursuant to this judgment, the OP number 4 has passed the impugned order dated 9/5/2023.
One, my lord.
OP number 1 has passed 9/5/2023. A copy whereof awaits at Annexure 14. First off. So far as prayer for regularization is concerned, comma, that appears to be rightly denied by the impugned order. First, however, on what basis, what justification the accumulated remuneration of the petitioner over the decades has been withheld remains a mystery wrapped in enigma. First off, there is absolutely no justification for retaining the wages by the employer, in as much as wages constitute property of the employee, and therefore the action is violative action is can be likened to the appropriation of citizens' property, sales compensation, which is violative of Article 300 capital A of the Constitution. First, next paragraph. In the above circumstances, this writ petition is allowed in part. First, the writ of mandamus issues to the OPs to pay to the petitioner wages
Remuneration, sir.
Remuneration during the period that has accrued and accumulated during the period between 10/5/1990 and 31/5/2018 within an outer limit of 8 weeks with the interest at the rate of 1% per mensum from the beginning. First term. If delay is broke, that would carry 2% interest per mensum which component may be recovered from the erring officials of the state government. First, the OPs are directed to pay a cost of rupees 25,000 to the petitioner who was made to hover in the court corridors for all these years with the 3 petitions. First, cost to be paid within 4 weeks, failing which for each day's delay, rupees 250 shall be added to it till actual payment is made. Okay. Yes.
Item 1 was passed over.
You make it the cost of 28,000 because 28 years are over. 28,000. This is the way. You can't harass the citizen. Even the Mughals did not do this. You are treating the people that way. They are the employees, yes.
Item 1 was passed over.
My lord, on behalf of London Senior Advocate, the Anmaptra, my lord, matter may be taken up day after tomorrow, my lord.
2015 matters.
Yes, my lord, we are ready, but he is suffering from throat infection in the morning, my lord. He mentioned, my lord, in the morning. In the item 34, my lord, he mentioned that he is suffering from throat infection, so he could not. But day after tomorrow, my lord.
Day after tomorrow? 2015 matter.
Yes, one is 2 matters are there, 2015 one and 2019 also.
2019 also.
The connected matters.
Day after tomorrow.
Interim order to continue.
Interim order to continue till then. Yes.
Actually.
Item number 2.
Well, there is a delay. The duration is much more than what your lordships have decided on 18/8/2025.
What is this matter?
This is, my lord,
Review.
a review application was filed, my lord, seeking order dated, my lord, FO 219 of 2020.
Review.
Yes. That was dismissed, my lord, because a batch of matters were dismissed because of non-appearance. That's why, my lord, your lordship is granted.
Your lordship has given judgment on this. The review is not maintainable.
This is a
against the FAO.
It is against FAO.
Yes, sir.
No review power.
I've seen your lordship's order, my lord. But your lordship can you see this order?
What is this order?
This is, my lord, a same appeal. Here, my lord, there is a same appeal.
Means?
That is not decision for default. That review application was decision for default because of non-submission of my certified copy. But ultimately, my lord,
no. Dismiss for default is not review. It is recall. I have differentiated review and recall in my judgment. Review is on merits.
Yes.
That is not permissible. Recall is always with the power. It is the power. Review requires a separate enablement by law. Recall is sufficient because inherent power is there.
This is against a recall.
It's a recall order.
Yes, yes.
He dismissed for default. Yes. I can't send him to Supreme Court. He will commit suicide. Yeah. a coordinate bench of this court with order dated.
My lord,
Dismissal order dated.
well, that is, my lord, 18/10/2019.
18/10/2019 had dismissed this appeal for non-prosecution. It dismissed FAO number 219 of 2012 for non-prosecution. First. Now an application supported by an affidavit is moved seeking recall of the said order. First. Next paragraph. Learned counsel for the learned AGA appearing for the OPs submits that this court in so and so that this one.
Give you picture number 234 by 2012.
234 of 2012 between
judgment dated 25/8/2000.
so and so dated 25/8/2025 has held that no review is permissible once an order is made by this court under section 28C.
Yes,
24C of Orissa Education Act 1969, and therefore the application is liable to be rejected. First, at once learned counsel appearing for the applicant points out that the said decision differentiates between power of review and the power to recall an order. And therefore, the latter is always available to the court which has dismissed the proceeding for non-prosecution. First, a plausible explanation is also offered for the delay proved in moving the application. First, next paragraph. In the above circumstances, how many days delay?
2007 days.
Delay of 200?
7 days. Because the delay is now because of non-filing of certified copy of the judgment.
Delay of so many days is condoned, and the coordinate bench order whereby petition appeal was dismissed for non-prosecution stands recalled, and as a consequence, that is FAO is restored to the board for consideration afresh. You give something to the bar association.
Well. Good. Here have not 2 books, here are 4 books. Because the delay.
Here we have said 2 books.
One.
Subject to the applicant presenting to the association library.
Ramaja's book could be there. Ramaja's administrative law.
He has not written any book on administrative law. On service law, he has written,
yes,
copies are not available. You give
Wade, my lord, Wade administrative law.
Wade administrative law by Professor Wade and Potsit. Within 2 weeks. Very good. And instruct your colleague to read also. Wade is a wonderful book. If one starts reading, one feels that he is reading Ramayana. Like that. So beautiful. Good book should be read.
And here my interpretation of GPC. Your lordship already.
GPC. Yes.
Item number 5.
Yes.
My lord, in item 5, I'm seeking a short passover.
Passover.
Well, in item 5, I'm seeking a short passover.
25 matter. We'll take the 2014 matter, admission. Take out old matter. Go to 12.
Item number 12.
Yes. If we take only new matters, what should happen to the old matters? Nobody will touch them. Start.
My lord, I've still the order cancelling my lease.
Cancellation of?
My lease granted by the lease. Granted for industrial lease, in fact, granted by the
industrial lease was granted to you. When it was granted?
Yes, my lord, I'm giving a short date. Sure.
Who is your opponent?
IDCO, my lord. I think Mr. Mohanty became.
I'm appearing for IDCO. Argue. Yes. No time will be granted. People will laugh at us. 2014. You know, we disposed of 1997. What people will say about that word?
May I submit your lordship?
Don't submit. After his submission, we can make submission. Yes. Yes, still.
In 2005, I'm just broadly saying, in 2005, the lease was granted in favor of the petitioner for an industrial land for construction of a hotel or implementation of a project for hotel.
Hotel project.
Yes, madam. That was a low-lying land, and I
have a mic with you, so that many will hear your sweet voice. Yes, and intellectual submission also.
That is a low-lying area. So I developed it by putting earth on it and constructed a boundary wall. Unfortunately, my father was ill, has some renal issues, so the implementation of project, what is called a hotel, could not be done up to 2014. That's an admitted situation.
Within what period you want to have done the project work? 12 months.
As per the lease deed, it is 12 months. Is written in the lease deed. I will go to that. I could not be done. Now on 16/7/2014, they issued me a show cause. I replied to them, stating that I have already implemented the situation. The ultimate project of hotel could not become because I also, but that's my reply. And I also asked them that please come to the site and verify this is being implemented.
What is that? Show it here.
My lord?
Show your reply to the Shoka note.
My lord, reply is at page 45.
Page 45.
Yes, my lord. Before that, may I show the soakers? They just page 44 is the soakers. My lord, it's the printed soakers.
You have kept the land unutilized and thereby rendering allotment
in purchase, and you have not utilized the land at H.
E and H.
H one. Now, my lord, see. Now, my lord, lordship, kindly come to my reply. The SOC is not, the allegations leveled against me in the clause CAE of the SOCA's notice is totally not correct. The land allotted to me for the purpose of project so and so has not kept unutilized. Rather, large number of development work has been made. Boundary wall is constructed with total plot around it and erected, involving 54 lakhs towards the construction. Since the plot was lootable, the entire area has been brought to usable conditions by putting 5 feet of earth, filling it so and so and paka. As regard to clause H of your SOCA's notice, I am to say that land is being utilized for the purpose of which it is allotted to me, and the process of which is such approval of building plan and finance from the bank are going on. Approval building plan they will have to give me. Now, my lord, I would therefore request you kindly visit the site and see the progress of work, since it is a big project and it will take some time to complete the project. This is my reply. Now, my lord, the cancellation.
They have done correctly. They have done correctly. It is given for a particular purpose. Time bound. If you are incapable, you back the site, it will be given to some capable person. How can you retain it?
My lord, I have 2 submissions in law. One, let's say the lease, it's a lease under the Transfer of Property Act.
Correct.
And clause 16 says the process for invoking that if I have committed some breach, how it is to be determined. Lordship can have that clause 16. I've quoted in my petition itself.
Where is that lease? Go to lease.
Lease is at Annexure 2, page 26, and your Lordship can find out that page 33 is the relevant clause.
3.
Yes, ma'am.
Now, where is allotment letter? Allotment letter.
Allotment letter is at Annexure 1. Annexure 1. ma'am.
Annexure 1. Let us see that.
Yes, ma'am.
Allotment letter is dated?
Dated 21st February 2005. And this allotment letter, subsequently the lease has been granted in terms of the allotment letter. More or less the conditions are similar. Conditions are similar.
You have made entire payment now.
Yes, madam. Entire payment, and I have paid the usual user's fees. That's called my ground rent and other usable fees mentioned in the deed document up to 2014. There is no fault in that.
Up to 2014, you have paid.
I have paid. And after that, they are not keeping it because they have cancelled it.
What they have done to others like you?
Let that
What you have done to others similarly circumstanced?
Your Lordship, for that I have to seek instructions. But Your Lordship, in this particular matter, Your Lordship, we have issued 3 show cause notices. One is dated 18/12/2008. Other is dated 27.
One is
18/12/2008.
Other
is dated 27/5/2011.
To 18/12/2008, did he send the letter? Any reply?
Your Lordship, replies were subsequently sent, but no work was done.
When it was sent?
Your Lordship, I am appraising Your Lordship for this.
No decision has been taken over those.
What decision to be taken?
No.
That we should notice and you have not done it. Simply you have to vacate. That's all. That's what the Supreme Court has said.
Your Lordship, no replies were given in this.
No reply sent to 18/12/2008.
Yes, Your
I
Lordship.
have not received.
And Your Lordship,
I have
last.
not received anything.
We stated.
But this is for the first time they are saying.
Your Lordship, after 2015, the matter wasn't listed, Your Lordship. But the counter was filed. Counter was filed. But Your Lordship.
Counter was filed.
Yes, Your Lordship. Counter was filed on 27/11 and 2015.
He says he has filed the counter also.
Well, today I have received the copy. But I'm saying that they have never solved the copy to me. I'm not saying that they have not filed.
All right, call Kumar.
No, I'm just making some submissions. So let's say with this counter. So I have just 2 points to make here. One is the lease under clause 16 statuted that says that you have to give me that this determination cannot be done. And section 34, the IDCO Act says that even assuming I have unutilized, it can only resume by making payment of the premium. So I'm not, these are the 2 points on which I have brought your lordships come here. If it is a lease, it is determined under the lease principle, under the Transfer of Property Act. That's number one.
No.
Otherwise,
Statutory lease.
it is not a statutory lease, and it is 34 is the only power where it says that resumption can be done. I have quoted it. What I beg to submit here is this, my lord. I may be granted, but then also I have seek, please see and come to my place and see.
Why they should come and?
Well, because the building.
It is your duty to start the hotel.
Building plan has to.
What we should do with the branding plan and with
building plan has to be approved by them. Other than their approved building plan, I cannot put constructions. That's the case here.
When did you apply for approval?
But I have applied long since. I have stated it in my counter also, in the showcase also.
Where
the building plan was applied to them.
When did you apply?
In 2011.
To give the date.
Well, I have not brought it.
2005. Then why you
Sir,
go home and bring it? I can't wait for you, dear.
No, my lord, I'm not saying that. Well, what I'm saying, what I'm submitting, my lord, is limited for lots of purposes. So the first and foremost is that it's a lowland area. I have constructed and make it usable and fit for the commercial purpose.
How you constructed without approval of the plan?
No. I have just filled up the area and put a boundary wall, nothing more. And then ask for the boundary for the approval.
When did you apply?
But that's the pertinent date. I can ask for my client to immediately offhand. I have no answers. That's the while that is pending. So even if they pass it today, I undertake before your lordship that I will implement the project within the time fixed by your lordship.
You have not done it since 2005.
2005 to 14, I can, your lordship understands this is a small town, hotel project, and I have to, in a low-lying area, they give this lease and as and where is basis.
How many years you took to fill up the low-lying area?
Well, there is some issue with financing and other things. I agree there. But even then, if they allowed me just that the period which is mentioned in the deed, it would have been sufficient. I will put it. Because initial work has taken some time.
What some time? How many years?
I agree. This is now, 1 year even today. It's a lease up to 2084 and I have already lost valuable time.
Lost means you have lost it.
Yes, I have lost. And I am actually to my prejudice. So why now they will take it and grant it to somebody for 3 years? Sir?
There are 141 crores.
I just pray your lordship that 1 year from today, if your lordship's order direction, I will implement the project.
Why I should direct? They have taken lease, they have granted lease. It is their land. You are the owners. You are not the owner.
Then I'm not the owner.
And you have not utilized the land for which it has been granted. What more is required?
And that's what I'm saying. There were some issues I have stated in my query and give me just 1 year from the date of approval of the building plan.
No, once it is given,
yes, madam.
Other person comes. You have given to him. Why not to me?
No, but it was.
What is the law?
It was open actually. It was not granted any. It was.
No, if some other person comes, for a person who did not comply with the condition for
34
years,
section 34 actually
leave.
Section 34 actually takes care of that situation scenario.
Read section 34.
My lord, I've quoted a lot of have that is 11 and directly taken to lordship clause 3 at place 12. If the board is satisfied that any plot holder has not utilized the maximum area of his plot or suitable for construction of building for the period of 3 years or more from the date of the possession, the plot delivered so and so. So to make it usable thing, the board, notwithstanding anything contained in contractor law in the time in force, the plot holder, all other interested persons, so cause as to why the unutilized portions should not be acquired for the purpose.
Right. It is completely unutilized.
My lord. And that's contingencies 4 and 5, everything. Resumptions, they can do. Why I beg to submit, my lord. Industrial land, I am ready today. They give me just 12 months time, I'll do it.
Where is the power to give?
Well, because they have not followed this law. They have to give me the showcase for 6 months, stating to remediate it. That's the lease condition required. 6 month time must be given. Lease is stated that 6 month notice to be given for remedying the defect. That has never been done.
You have taken a site for particular purpose.
My lord.
And now you are finding loopholes with them.
Your lordship,
instead of
property,
You are now making all this that will not help you in this court.
No, my lord, therefore I'm saying that it's a business commercial situations. If they grant me 12 months time from the date of granting me the building plan, that is what I'm saying. I'm going before a equity court. I am not contesting the situation. What I'm saying is this, my lord.
Objection statement. What you state?
Your lordship, in counter affidavit, we have in detail we have described the scenario. Your lordship.
What are the grounds here? What is that you have taken?
Your lordship, 3 show causes were issued. No satisfied.
Subsequently, what you have done is irrelevant. As on the date he came to court, you had issued only one, 16/7/2014.
Yes, your lordship. After that,
now I am asking you.
Yes, sir.
To others, any concession is shown?
No, your lordship. As far as
no concession.
No, your lordship. No concession is there.
In all such cases, you have cancelled.
Yes, your lordship.
And you have resumed the sites.
Yes, your lordship.
Nobody went to court.
Your lordship, for that I have to seek instructions. I have to see subsequent matters, your lordship, for that. But in this case, your lordship, if a person cannot complete the work within 12 months.
No, for 12 months from which date?
From the date of allotment of the land.
Allotment.
Yes, your lordship.
The allotment letter is dated.
Allotment was done on
21 February 2000.
Yes, your lordship.
Possession the possession of the property.
16/6/2005, your lordship. I mean 16/6/2005, your lordship. 16 June 2005. Possession was given.
Lease was executed when?
Lease was executed on
July. 1st day July 2010.
17.
Yes, your lordship.
2005.
5, your lordship.
5.
First show cause was given on 18/12/2008, as the work wasn't complete at that time.
How it was sent?
They have not even annexed to it, those stated.
How it was sent? Was it by Udam, by police, by postman?
Your lordship, so that will
what you have stated in your petition, it was sent by how? How it was sent?
Your lordship, that I'm apprising your lordship. Your lordship, letter was issued 1269. Notices were served, your lordship. Notices were served, but
how?
Served to petitioner by divisional head ITCO, your lordship. By
divisional head went to his house and
no, your lordship, no, that I have to seek instruction, your lordship.
What for everything instruction to this sort? I don't understand your bar at all.
Your lordship, the letters are sent.
Sometimes I feel I'm sitting in some other bar.
Your lordship, the letters are sent by post only.
Where is that you have stated?
That your lordship, in counter we haven't.
But when you're all panel advocates appearing for the authorities, and people will be seeing that I am troubling you so that they may change you. Why they should retain incapable advocates on the panel? How to protect the public property?
Your lordship, senior counsel will be appearing for this.
We don't know who is senior, who is junior. We don't differentiate also. It all depends upon performance quality. That's all. I don't see who is senior. I don't come behind and see your gown, whether it is senior gown or junior gown. I can't do that sitting here. Whoever does his best, he snatches the order from my court. What I should do with your senior? I don't need any senior. I want here those who perform well. To them I award. Have you ever seen I'm doing anything based upon the face value? No, nothing like that. I don't see gown, I don't see face. I just hear the argument, the demeanor, and merits of the matter.
Your lordship, notices are issued. They go to the spots as per my
repeating. I'm asking how you sent that notice. He is not answering. You are not answering.
Your lordship, as I have studied in previous cases, I have seen, your lordship, the notices are sent by the officials of ITCO. They go to the spot and put up the.
Where have you stated like that?
Your lordship, that particularly I haven't stated here.
Then you enter the witness box. I will cross-examine you. You are not supposed to argue beyond the parameters of your pleadings.
The last show cause was on registry post, it is stated.
It was, last one was sent by Registrar.
Registrar.
To that we have sent the reply.
Yes, ma'am.
But how to permit you to retain the property? Otherwise, the state industry will not grow in the
That's
state
what
at
I'm
all.
saying.
This is one of the reasons why this is a laid-off state.
And that is exactly, my lord, my submission is that 1 year is from the date of.
No, you have not done anything since 2005.
No, because of this litigation 14 to 25, we have lost, my lord.
Leave 14 to 25.
Yeah,
I am responsible.
But
what about the
before that, I have actually developed the land and they
developed your land.
Because it's a very low lying.
That is not development. Development has its own meaning. Under the Urban Development Authorities Act 1992, your Act 82 Act is there, na?
Yes.
Under that, they have defined what is development under the rules. Development is not that. Development means bringing the structure up to date and making it useful for the purpose for which it has been allotted. You are putting a few stones this side, that side, and 150 milligrams of cement. That will not amount to development at all.
That. What has lost, my lord, lost your lordship, and this I just
dismiss it.
No, my lord, one they have to give me the plan.
And you're not answering my question. When did you apply for the plan? That's not your case. What is your reply? Go to show your reply. Because you did not give me the plan, approved plan, I am not able to put up the structure. Show that.
Kindly in the reply, second paragraph. And the processing words such as approved building plan, finance from the bank are going on.
Where are they going on?
Because I have applied to them.
When did you apply?
No, that's exact date I offend. I cannot
decide unless date is given. How to run? We have to run from the date only. Time, date, etc. They are necessary for deciding that. It is not your case that I have applied for the building plan. You have not given the approval. Therefore, I could not do anything. That is not your case. Your case is your reply.
Yes, madam.
It cannot be improved by pleadings. And much less by argument. Your whole case is your reply. There's show cause, your reply. Nothing beyond that. Where have you stated? Yes, you have given me the leads on 1/7/2005. I have developed everything. I applied to you for approval of the building plan. You did not do. Therefore, my hands are tied. That is not your case.
Not the way your lordship saying that I have not stated.
That
way.
It should be that way. It cannot be the way. Therefore, the normative process of law. That you will say something, I will say something. No, I have set the parameters, how these things should be.
So, my case here is before your lordship is that twofold, that they have violated clause 16 and violated section 34 in doing it. It says 6 months. They have given less than that in the SOCAS for determination, and now I'm just not without contesting. I'm saying that if your lordship permit me one.
Where is my power? You have appointed me to do things according to law, not as a Babar or Jahangir.
Your lordship relegate me. I will go back to the authority.
Where is the case for relegation? Where is your building?
Then I have given a revocation letter that they have not been considered till date.
That's the question of
the question, your lordship can consider. I have already committed given the money, huge amount of rupees, 10 lakhs rupees, or they have given and then developed it to up to by spending time. Because of
what for it was given to you?
For implementing a hotel.
Why hotel? Because it is an industry.
My lord.
Many people will come to this place. They will stay. And many people will be given employment. The money is generated, income is generated, employment is generated. And the name and fame of the state is generated, upgraded. That is the object of industry.
Since your lordship is adjudicating my fault of 2016, 2025, I pay just 1 year. That's the equity.
If it is given to you, that becomes right to others.
No, my lord, since it is I have paid the entire price and
Just dismissed on the ground that the allotment was made by the letter dated 21/2/2005. The lease was granted on 1/7/2005, specifically stipulating a period of 12 months for accomplishment of the hotel project. First, that has not happened. First, notice was issued on 16/7/2014, proposing to rescind the allotment. First, petitioner sent his reply dated. Your reply is dated?
my reply is, my lord, 7th of August. 16/7 is there so cause my reply is 7th August.
7/8.
2014, Your Lordship.
2014, wherein no plausible explanation is given as to why the project could not be accomplished. First one. The next one, the submission of the net counsel for the petitioner that the approval to the building plan is going on, and bank financing is also going on, and therefore one more chance should be given to a client to accomplish the project. First, this court has no such power to travel beyond the parameters of law and policy. First, when the land is given for a particular purpose on this basis, lessee can retain the lease only by accomplishing the object for which the lease was granted. And when that has not been accomplished, and there is no fault on the part of the lessor, lessee is liable to lose the lease and to suffer rescinding of the allotment letter. First, in the above circumstances, petition is dismissed. Petitioner is directed to deliver back possession of the property to OP number
1 and 2, Your Lordship.
1 and 2 within a period of 8 weeks, so that the same would be allotted to other entrepreneurs on a normative basis. First,
They may be permitted to resume by adhering section 34.
how can that be?
Resume because that's the.
The whole state, no industry is developed.
No, we can resume, my lord. Now they are.
Every alternative week I travel by flight. Every alternative flight. I will be just observing. I come from therefore Dravida, Utkala, Banga. Banga, well, see the Dravidian lands, how they have been developed. And American president said, from Buffalo to Bangalore. Buffalo is in US. From Buffalo to Bangalore, he said he did not put Orissa at all, Bhubaneswar at all. Because the things are not happening. Industry is not coming up. Power is not coming up.
What I'm saying is that let them resume it under section 34. That's the law.
Next. All then, 5. First roadmap. Yes.
Please, Your Lordship.
Item number 5.
My lord, item number 5, it's a fresh matter, my lord.
Fresh matter.
The coordinate bench of this honorable court had passed an order, my lord, for notices to be issued, my lord. That order is dated 23/4/2025.
Whether Panigrahi had
And that's correct. My lord, there, my lord, the notices were directed to be issued within 3 working days. My lord, unfortunately for us, my lord, there was some delay in uploading, so we filed it, but unfortunately it has not been
requisites were furnished belatedly to be processed immediately. Okay.
Matter may be come up after that moment.
Okay. To post-doctor service.
Deeply obliged.
You said that you would be giving that decision.
I have already given it.
Okay.
I have given a copy of.
Item 6 is still there? 6 to 11. Yes, come. In the first list. In the second list. Okay.
My lord, may fix a date of this.
No date can be. The service should happen and that will.
That's why they put a returnable date according to the date that you fixed.
Therefore, post-doctor service.
Deeply obliged.
Next.
Item number 6.
There's an application for amendment of the writ petition.
Amendment?
Yes. I just wanted to incorporate one paragraph in the original writ petition. It is earlier I was before this honorable court. There was a...
you had not mentioned here.
No, I have mentioned, but the particular quoting I had not given. I had mentioned in the first certificate.
Petitioner has moved an application seeking, supported by an affidavit seeking leave of the court to add a certain portion to the pleadings by way of amendment. First, have you served the copy on the other side?
My lord, copy has been served.
Copy of the application is served on the other side. And no objections are filed to the same field date. First off, the amendment sought, if granted, would not alter the nature of the case. First off, on the contrary, it may facilitate due adjudication of the lease brought before the court. Next one, in the above circumstances, application having been favored, leave is accorded to amend the petition as sought for. First off, petitioner to file the amended petition within 2 weeks. After serving copy thereof on the other side. First off, OPs may file their objections for additional counter, stroke additional counter within 2 weeks thereafter. Call up to 4 weeks. Next.
Item number 8.
I have agitated the order passed in a revision petition.
Yes.
The order passed by the first ADJ Rourkela in a review petition. While the first appeal RFA 30 was already dismissed in the first appeal and not entertained in SLP. In spite of all this background, Your Honor, in a revision petition under 115, the first appeal decree and judgment was interfered and interpolation was made. Not exactly interpolation, something was added to it in a revision petition. So I have filed, Your Honor, petition IA also to assign the same to a division bench because it's against single bench order.
How to send to the, it's a 115 petition and already disposed of.
Your Honor, it is not exactly disposed of because it is remanded and directed the lower court to do such and such matter. It is not disposed of. It is remanded.
It is remanded.
Yes, Your Honor.
Remand also is a disposal. After remand, nothing, no paper remains on the court's board.
Your Honor, if it is not done according to the order of the revision court, I can always agitate that.
Which order you have sought for? Dispose of CMA number 3 of 2018 within a period of 1 month positively from the date of appearance of both parties. What happened to CMA?
CMA was dismissed.
Dismissed. And that order cannot, that have you challenged that order?
So it was dismissed in my favor.
Dismissed in your favor. You were upon.
Your Honor, the defendant has filed the review petition against the order of the RFA. Instead of filing the regular second appeal, it filed the review petition which was rejected because it was more in the nature of appeal itself. Against that order, after it was dismissed, then the defendant preferred the second appeal which was also dismissed being time barred, which was also dismissed in SLP. Thereafter, the defendant came in this revision to attack
the review petition after a lapse of more than 2 years, Your Honor. At this threshold, this revision should have been dismissed because it was filed after 2 years. But that was neglected or overlooked.
No, what is that? What you want me to do?
Your Honor, the order passed in the revision petition is without jurisdiction and was prima facie barred by remutation and should not have been passed by the regional court. And that should be set aside. Once it was dismissed in the appeal, regular second appeal, even up to learned Supreme, SLP also was dismissed. In a backdoor method in filing a revision, the RFA was disturbed.
Who is your opponent, sir?
So he has to be noticed, Your Honor.
Notice to be given in this.
Yes, Your Honor.
Go to the player column. How can that be set aside?
Prima facie it was hopelessly time barred.
No, that's all right. 16/4/2025 is the order of brother judge.
Yes, Your Honor.
What?
16/4/25.
Is correct.
Yes, Your Honor.
Kindly take me to 16/4/25 order. Page number?
RFA was annexure 6.
16/4.
Page 54 to 55, Your Honor.
Yes, how can I set aside brother's order? You should either seek review, some recall. This one I cannot set aside by another. You have filed another WPT.
Your Honor, I have also filed IA to assign it to the division bench, Your Honor.
To division bench?
Yes, Your Honor. As a WL.
How can I send the division bench? There is no. This is under 227. Under 227, there is no intra-court appeal.
The substantial question of law is involved here.
That is in RSA. The idea of substantial question of law is under section 100 of CPC, not in this. Error of jurisdiction, refusal to exercise jurisdiction, defeat of justice. These are the three grounds which learned brother judge has looked into. He has passed that. If you are aggrieved by that, you have to find the SLP. I will reserve that liberty to you. It cannot be the division bench. There is no such thing.
Therefore, my client will be too expensive to seek High Court, Supreme Court.
Always costly things. Lawyers are costly nowadays, like you. What to do?
Some relief is, if not given, I will be highly prejudiced.
But if relief is given, as a judge, I will be prejudiced.
It may be assigned to a larger bench.
Now, how? On what ground I can send it to larger bench? Which law? Show that. Which law provides for that?
Under LPA, Your Honor.
Huh?
LPA.
What is that?
Latest patent appeal.
No. No. I permit you to make an application for recall of this order. You seek a review petition.
Yes, Your Honor. Yes. Oblige, Your Honor.
Go to the cost statement. This petition is filed seeking to recall. Go to the order. There, follow. The order dated 16/4/2025 entered by a coordinate bench of this court, whereby CRP number 20 of 2024 having been partly favored, matter was remanded to the court below for disposal afresh in a time-bound way. First. Next paragraph. Learned counsel appearing for the petitioner vehemently argues that the CRP itself was not maintainable and that it was filed after brooking enormous delay and therefore the subject order needs to be set aside. First off, I am afraid that it cannot be done. First off. Obviously, the subject CRP was filed under section 115 of CPC 1908 as amended, and therefore, after the remand, no papers remained on the board of this court. First off, it hardly needs to be stated that a remand is also a disposal. First off. Next one. The second submission of learned counsel for the petitioner that the matter be referred to the larger bench does not impress this court, to say the least. A matter cannot be referred to the larger bench when already it is heard and decided between the very same parties by other bench. First, next one. In the above circumstances, this petition being unworthy of merits is disposed of without interference, reserving liberty to the petitioner to seek review or such other appropriate proceedings in accordance with law, if he is so advised. You seek review of that order.
Item number 9.
Yes, sir.
Item number 9.
Which year? 25. 4 weeks to enable counsel. Ready?
Lordship, one pass over, Lordship. One pass over. One just. So you can take it up next week.
Next week.
I file an amendment petition, Your Lordship. That's
that amendment application will allow. We'll counter to that.
There's some new fact and document, Lordship. Need some instruction. I've already served this copy, Your Lordship.
When it was served on?
I've already served.
When?
So 5 days before, Your Lordship.
5 days before. 1 week they have got, na? Okay. Call after 2 weeks. In the meanwhile,
and only premature withdrawal, Your Lordship. Only silly matter, Your Lordship. Premature withdrawal. 250,000 deposit in the National Savings Account. That is premature. They have denied the premature withdrawal, Your Lordship. That's why we file an amendment petition. That our prayer is that
you want a premature withdrawal of the deposit.
My Lord.
What for?
Gazette notification is there.
No, it's all right. What for? For opening wine shop or what?
The hard disease of the father of the petitioner and is the married, Your Lordship.
Marriage.
Next week. Tomorrow. Next week.
They want money, their money back.
Well, I have already.
Lordship, this matter assigned to Mr. Sudipta Panda. He is suffering from viral fever, Lordship.
Monday.
Only next week.
Monday, Your Lordship.
But that virus will not go that easily, na? They take their own time.
As per instruction, he is ready tomorrow.
Next week.
Next week, date, Your Lordship. Otherwise,
the next one. On the health ground of counsel representing the respondent. OP. Yes.
Item number 10.
10 is of which year? 21st. Call after 4 weeks.
Item number 11.
No, why is you are taking 25? This one, old matters are there. Start old matters at least because of the old matters. So 12 is over now.
These are for orders.
On
All
behalf
the
of Mr.
25 matters, these are for orders.
On behalf of Mr. Sahul is not there. He has requested me to make a mention is because the notice admission could not be issued due to non-filing of the requisites. Today, he has taken steps.
Requisites to be processed. Post after service. Next.
Item number 13.
Mercy, my lord, dated 1/8/25 order, your lordship may see. 1/8/25, your lordship has a call for the documents, your lordship, from the government. That has not come. Besides that, my copy of the counter has not been served to me.
Please, it is ready with me. If you want to take it from today, on today, you can receive from me.
That copy is ready, but if you are away, what he should do?
No, my lord, my junior is there, my lord. I can receive it.
Nobody is here.
Just call out your name of yours. I tell you the name. We'll call him.
My lord. My lord.
So far as records are concerned, my lord, it was, I had seen that record, it was with the file, my lord, but probably it is left in the office. I will bring that.
Call next week. Now the next days of hearing, records will be kept ready.
Yes, my lord.
Item number 14.
My lord.
Yeah.
This case was before your lordship, by which, my lord, for 11 years government had not filed counter. Your lordship import 2,000 per year, 22,000 they have paid.
They have paid.
And within 11 years, my lord, they have not filed counter, but when your lordship directed within 11 days, they have filed their counter.
Perhaps that is the only relief that can be granted to you.
No, my lord. Main relief is there. Your lordship also directed on the last occasion to my Lord government advocate to come with a positive response. Because, my lord, they were working. Your lordship may kindly come to page 24, my lord. Earlier, this petitioner has come to this honorable court, my lord. The direction of this honorable court is there. Page 24 of the writ application, my lord.
Saying?
Paragraph 2, I am reading, the petitioners who were working as NFE instructors under the government of Orissa filed this application seeking for a direction to consider their grievance for observation in the category of Gana Shikshak in accordance with the guidelines issued by the authority from time to time. Mr. So-and-so submits that the petitioners having engaged in NFE instructors have gained experience in the matter of teaching. Subsequently, the NFE scheme has been abolished with effect from 31/3/2001 and new scheme, that is Education Guarantee Scheme and Alternative Innovative Education, was introduced for which guidelines were issued for selection of EV. As per the EGS guidelines, some of the NFE employees have been observed as education volunteers, leaving aside the claim of the petitioners. Because, my lord, thousands of persons they have considered, we few they have not considered. Hardly 20 to 30% they have not considered.
My lord.
Standing on the similar foot to others.
His case cannot be considered because we have given engagement as Gana Shikshaks all the retrenched NFEs, those who were working in the government concern. Here, my lord, this man petitioner was working under an NGO. That's why his case was not considered.
No, my lord. NGO also they have considered.
My lord, counter at paragraph 6.
My lord.
The 16 to 2008 notification clearly states that the education education volunteers retrenched
from government service.
No, retrenched from EVs, retrenched EVs shall be given engagement as Gana Shikshakas. He wanted to be a Gana Shikshak. That his case was not considered because he was working under NGO. All the government school, his education.
NGO?
Yes.
paragraph 6 of the counter, your lordship may kindly see. This scheme was implemented that at the outset, this deponent humbly submits that for universalization.
Clients are working.
No, my lord. Annexure 4, their government letter, your lordship may kindly see.
No, let us see. Were you working in NGO or not?
My lord?
Are you NGO employee or not?
NGO run non-formal education.
My lord, what they have done, almost all persons, they have come through NGOs.
No, sorry.
Then, my lord, I pray, day after tomorrow, similar matter is coming. Day after tomorrow, I am giving the number before your lordship.
Give.
So that will help this case.
Or it will help that case.
Yes. My lord, I have given the number. It is coming day after tomorrow. Your lordship has posted.
Come along.
Yes.
Next.
Item number 15.
Yes.
My lord, on behalf of Mr. Lalitendu Mishra, I pray for adjournment, my lord, in this matter be taken up.
Adjournment, 2018 matter. Not ready.
My lord, he is out of station.
If your senior tells earlier, I also would have gone out of station only. I come here to work. 2018 matter, 16 matter, 14 matter. Now that reluctantly adjourned by 2 weeks. At the request of counsel for the petitioner. Yes.
Your lordship, interim order to come.
Increment is also there.
Yes, ma'am.
Item number 16.
Yeah.
May please, your lordship. Lordship, may kindly consider your lordship's last order. Order number 10, dated 12/8/2025. I want to draw your lordship attention to paragraph number 2, the last but 2 lines at the bottom. However, in respect of other component of the outstanding amount payable to the petitioners, the approval has to be obtained at the hands of the higher authorities, as has been observed by the brother judge. Till date, there is no information as to the approval having been granted or denied. In the above circumstances, learned AG is granted a period of 4 weeks to comply with the direction.
Yes, Mr. G.
My lord, nothing has yet been received, my lord. Lordship may give me some more time.
I will give time provided you comply with the order. Brother's order has to be complied. Otherwise, I will direct arrest and detention of your officers.
My lord, Lordship may give me some time. Let me take instruction.
My lord, may I only for the for utmost clarity of my learned senior and your lordship, but in the counter itself, if your lordship kindly has a glance at the counter for a moment.
No, in fact, that is in the order itself, it is mentioned.
Yes.
Brother judge has already mentioned.
Hello.
The approval is granted.
No, my lord, approval was granted for the security deposit. Approval was granted. My lord, a document was handed over to the Honorable Court on that particular day, where they said, my lord, the security deposit is being released. There are now 2 components. The interest on the security deposit, that was one component, and the other are rest of the amounts.
What was that money?
My lord, what are the rest of the amounts? Yes, my lord. My lord may kindly have the rest of the amount is one is price escalation, and the second being the differential cost, both of which has been admitted by them in the counter. That is what I was wanting to canvas before your lordship.
They have admitted.
They have admitted. It will only take 2 minutes for my
Page number?
My lord may have the counter. My lord, the counter affidavit. My lord may have
B/4 annexure.
Well, if I
Last paragraph, moreover, your other claim pertaining to escalation and differential cost of steel and cement amounting to 1,01,05,000 so respectively, excluding the interest as per provisions of the agreement, will be released after approval from the competent authority.
But the competent authority will approve provided he does something.
Yes.
What he should do? Who is the competent authority?
The government.
No, government means who? Home Secretary. Why he is not approving it? Very simple. What people will think about him here? You show the video clip of the court.
My lord, chief engineer is the competent authority.
All right. We'll ask him to be personally present before the
No,
court.
lordship may give me a week's time thereafter. Lordship will direct that.
Call next week for reporting compliance of the order dated
Well, your lordship's order is 9/7.
9/7/25 and 12/8/25.
12/8.
Failing which some coercive action may be taken against the competent authority who is responsible for taking a decision on approval.
May I
Yes.
request a date, madam? May I request?
Come next week.
If you bless.
One day this side.
If you bless.
Item number 17.
Maybe. Even this case, my lord, my limited prayer here in this case, though I found my name in the select list, but for the laches of the authorities, it was delayed and I was given appointment only after a contempt petition was filed before this Honorable Court.
The select list was prepared when?
That is in 2006, madam.
2000 date?
One. I have given a note, my lord. That was on
16/12/2006.
my lord.
But appointment order was issued when?
Only in 2018.
Why you are not giving the dates? Only you
Sir, I have given it. I have given it.
in love with the year calendar.
No,
But I need the dates also.
that dates I have given a date chart. I am just placing it, madam. There is. I am just placing the dates.
2018.
My lord, 14/10/2006 was the advertisement.
14/10.
And the provisional merit list was published in December 2006.
1 second. 14/10/2006 is the
Advertisement.
invitation.
Advertisement for the post of
For the post of
Shiksha Sahayak.
Shah Sahayak. 16/12 is select list.
December 2006, Annexure 2 is the select list.
No date.
No, my lord, exactly, because I have got it.
16/12/2006, somewhere you have said.
Yes. 16/12 is the date.
Date.
My lord.
All right. Then
Annexure 2. My name found place in the select list.
at serial number?
It is, my lord, in the SCBC category, it is in serial number 4.
SCBC
But,
means
socially educational backward class. Socially educational backward class. Like that of my lord OBC, the central government.
You are issued appointment order on 3/8/2018.
My lord. What happened in the meantime? What is the difficulty I faced? My lord, though the select list was prepared, I was not given an appointment. So I came before this Honorable Court. That is on 13/10/2007. My writ petition was disposed of with a direction to the authorities to consider why he has not given an appointment.
WP number?
WPC number 13075 of 2007.
Disposed of on?
31/10/2007.
31/10.
Yes. It was a direction to the collector to decide the issue in light of a judgment of this Honorable Court in the case of Chandramani Jana. That is a reported judgment, my lord, wherein or the same selection.
31/10/2010.
31/10/2007.
7. Yes. To consider.
To consider the representation in light of a judgment of this Honorable Court on the issue. Because in that Chandramani Jana's case, my lord, this Honorable Court division was held. You cannot restrict appointment on the case of in the place of birth. What they have done, they have segregated the appointments only in respect of a particular block where I born, I can only apply for that. That was the advertisement. That was challenged before this Honorable Court. And the law has been laid down that no, you cannot restrict on the ground of residence. One can apply for anywhere he has the interest to apply. So that was the judgment. So my case was allowed, directed to consider in light of Chandramani Jana's case.
So when that order was not complied, I have filed a contempt application, CONTC number 409 of 2008. CONTC, contempt case. CONTC number 409 of 2008. Then what happened? Thereafter, immediately after received the contempt order, they rejected my claim on 25/2008.
Contempt was decided on which date?
12/5/2009.
Dropped.
Not dropped, my lord, that was direction given in the first contempt. It is, my lord, you consider 1 month more time was given to them. So that was decided on 12/5/2009.
Then they rejected your claim on which date?
They rejected my claim on 25/2008. After I filed the contempt, they have rejected. Thereafter, contempt was dropped. 25/2008.
20 May.
Yes.
Then what happened?
Again, my lord, I have filed a writ petition. WPC 28727 of 2011. 28727 of 2011. Again, it was disposed of on 28/8/2012. That writ petition. Saying that the petitioner's case will be considered in light of the judgment, same judgment. That's Chandramani Jana's case.
Dated
28/8/2012.
In the light of
that Chandramani Jana's case, there is a report.
What it said?
It says, my lord, actually that you cannot prevent a person to apply to a block where he doesn't belong to.
Confining it to a block.
You cannot confine to particular for application. That was the original advertisement. There is a condition. That was set aside by the Hon'Ble Court, holding that it is violative of Article 16(2) of the Constitution. So, thereafter, my lord, collector has passed an order on 23/2/2013. That only appointment can be given to the petitioner after getting a clearance from the state government.
Yeah.
So when no action was taken, further action was taken, so I filed again another contempt petition, CONTC 726 of 13. But in the meantime, against that order in WPC 28727, a writ appeal was filed before this Hon'Ble Court. Writ appeal number 267/14.
of 2014.
That was dismissed on 23/7/2018.
That was against order dated 28/8/2012.
Yes, my lord. In WPC 28727. And that was dismissed on 23/7/2018. And when no further... Sorry. 23/7/2018.
Hereafter, they gave appointment when?
No, they have not given any appointment.
Despite it, they have not given.
No. So I have given it. Thereafter, I filed another writ petition. They give me an appointment. That is in WPC 12624 of 17 I have filed. And
WP
16624 of 17.
16624.
12624.
2624 of
17.
Decided on?
That was, my lord, 1. Two 8/18.
Holding
inter alia that the earlier order passed by this court should be complied with by the authorities. In the meantime, my lord, the person, those who are appointed, those are selected and appointed, those selected along with me and got the appointment, they have already been regularized because the scheme of regulation is after 6 years, a CASAC is to be regularized as a regular teacher. So they got the regularization. So against this CONTC number 726 of 13, I filed an IA because that was not complied with, because the Honorable Court has stated that 1 month you have to comply the order. So I filed an IA, and that was there, my lord, the court has taken cognizance. After that cognizance was taken in that contempt application, the collector has issued me the appointment order on 3/8/18. Yes, brother G, my lord. Why, how many times he has spent whole of his life in the court. Perhaps if he had a law degree, he would have been most eligible candidate for coming this side. How many writ petition? The business of litigation. Of course, we are also responsible. It's another thing. But it's a whole business is, if you write occupation, court litigation.
My lord, so far as counter is concerned, my lord, paragraph 6, your lordship may kindly have a look.
My lord, one judgment, my lord.
Which judgment you are saying?
That is the Supreme Court judgment.
Yes.
There, my lord, the Honorable Court has held. If for similar type of problem, I will get my prayer is here to get the retrospective, notional benefit at least from the date my batchmates have got the appointment. So that I could have got the regularization and other thing. Now in 18 I have joined, I am only entitled to be regularized only 2024. That's the difference. This is the judgment point.
What it says with
My
prospective effect.
Yes, only to give the benefit at par with the others. Those who have been selected along with me. Para 21, 22, 23, my guardian.
Service benefit.
Yes, notionally also. That court have said. No financial benefit. Para 21.
Pritilatanando's case.
Yes.
From your state it is.
No.
Yes, yes. No.
Yes, it is our Odisha High Court.
Yes,
Para 21. Shall I read, man?
Judgment another court is it? So, Odisha case.
Salary and other things cannot be given, but notional appointment. Notional appointment. So that, my lord, I will get the benefit, at least regularization from along with my friends, those who have joined 2018. And the consequential, I will get some benefit, financial benefit also after that. Yes, sir. Following that, my lord, there is a division bench judgment of this Honorable Court and as well as a coordinate bench judgment following the same ratio of that Pritilatha number. This decision. Anyway, there is one judgment here. Yes, that law declared by the Supreme Court. By. Is it? I guess then law declared by the Supreme Court and is followed by other High Court is not the wording of 141.
My lord. So far as the counter is concerned, my lord, the opposite parties in compliance to your lordship's order had given appointment to the petitioner only in the year
on 3/8/2018.
3/8/2018.
Yeah.
My lord, steps are being taken to regularize the service of the petitioner with effect from 6/8/2024 because he's completing the 6 years of service in between. Thereafter, my lord.
But why did you not give the appointment earlier?
Earlier it was, there are some judgments, but he speaks, my lord, it comes on the way, and he was found eligible thereafter. My lord, Supreme Court says, my lord, in case of, this honorable court in case of Vidyut Lata Dixit versus State of Odisha. The High Court of Orissa Kotak, while relying the judgments of the apex court, my lord, it has stated that the order passed by the Honorable High Court, seniority cannot be given on retrospective basis when the employee has not even been in service. My lord, that's why, my lord, I am submitting that he cannot be given retrospective seniority. We cannot give because by then now, my lord,
give him.
My lord,
Yes.
now, my lord, the post is not lying vacant as on that day. If there is a post.
He will agree that seniority is a larger issue. It will create many disturbances because already persons are there on the list. I can understand.
Yes, provided, my lord, he will be adjusted against a post, provided there are vacancies.
No, already you have appointed him.
No. He got appointment in the year 2018.
Correct.
But it was an advertisement of the year 2006.
Yeah, therefore, from the date his colleagues others were appointed.
Yes. Therefore, my lord, in the year 2006, the vacancies may not be available there. Unless the vacancy is there, how can he be adjusted?
Why did you call for invite the applications?
My lord,
we have vacancy-based notification.
Yes. Those vacancies were filled up
by others.
By others, my lord.
But because of your point, why he should suffer? So when he was entitled to be appointed.
My lord, it is my submission that there is, if there is some vacancy, since there is no vacancy, he cannot be adjusted.
No, my submission. So you have given him.
We have given him pursuant to your lordship's direction.
Yeah.
We have implemented the order.
Implemented. Okay.
In the year 2018.
Notional benefits. For giving notional benefits, why there should be vacancy? The notional benefit is given because there is no vacancy.
Unless there is a vacancy, how against which post?
What is his fault? How many times he should come to the court? He can write his autobiography. That will be autobiography of the court itself. Many times. People tolerate all these things, I do not know. Maybe because they believe in Jagannath, Lord Jagannath, and they say, maybe only this much I am entitled to.
But dispose of the matter, but this is my contention.
Understood. Take note. Basically. But
Vidyut Lata Dixit Vidyut Lata WPC number 13965. Relevant no in case. 13965.
petitioner who had bought a slew of petitions before this court has structured his prayer as a next one. Learned counsel for the petitioner submits that once name of a candidate rightly appears in the select list, selection process having been duly accomplished, he will have some right to consideration for appointment, subject to all just exception. First, the advertisement was dated 14/10/2006. Petitioner, along with others, was in the fray of selection, and final select list came to be prepared on 16/12/2006, wherein he figured at serial number 4 under SCBC category. First, however, he was not given appointment. First, petitioner had filed WP number 13075 of 2007, wherein a coordinate bench-wide order dated 31/10/2007 directed consideration of his case. First off. Thereafter, he filed Contact 409 of 2008, and at that time, his candidature was rejected by order dated 20 May 2008. First time. That led to filing of WP 28727 of 2011, wherein another coordinate bench directed by order dated 28/8/2012 to consider case of the petitioner in the light of Chandramouli Jena versus so and so. First time. Thereafter, the collector passed order dated 22/3/2015 to offer appointment subject to approval of the state government. First time. In the meanwhile, against order dated 28/8/2012, writ appeal 67 of 2014 was filed by the state, and the division bench negatived the same with order dated 23/7/2018. Just correct me, even I'm giving dictation if facts are wrong, then okay.
I have given it date chart that is there.
Date chart I have given.
I have given.
I am just referring for
Yes. Yes. I have given it serious.
Even thereafter, the appointment eluded the petitioner, eventually resulting into he filing another case in WP number 12624 of 2017, which came to be allowed by another coordinate bench-wide order dated 2/8/2018, and ultimately petitioner got secured appointment order dated
3/8/2018.
3/8/2018. Therefore, counsel submits that his appointment should be treated with retrospective effect from the date on which the others in the select list were given, with all consequentials. First, next one. Learned AGA, having entered appearance for the OPs, has filed the counter resisting the petition, contending that inter alia contending that when all vacancies were exhausted in terms of the select list, no post was available in which the petitioner could be accommodated, and therefore, to do justice, he has been accorded the appointment order, although bit belatedly. First time. When the appointment order is issued, only then the contract of service begins, and in the course of time it attains the status wider Tulsi Ram Patel versus Union of India. That being the position, the benefit cannot be claimed for pre-status period. So contending. Anything else you want to say?
No, it was fine.
So contending, he seeks dismissal of the petition. Next paragraph. Having heard the learned counsel for the parties and having perused the petition papers, this court is inclined to grant indulgence in the matter as under and for the following reasons. A. There is no dispute that the recruitment process began with the advertisement dated 14/10/2006, in which petitioner and others had participated. First, the final select list was drawn on 16/12/2006, wherein petitioner's name figured at serial number 4 under SCBC category. First, appointment orders were issued to all others, and strangely and stepmotherly, that was not issued to the petitioners. First off. Next paragraph. Petitioner had to fight too many legal battles, the particulars of which have been furnished above. And at the long last, he secured the appointment order only in December 2018. Absolute,
August
3/8/2018. Absolutely no fault attributable to him, but attributable to the officials. First, for fault of the officials, a citizen cannot be punished in a welfare state which is constitutionally organized. First, therefore, the contention of the learned AG cannot be fully accepted. Next one. All the above having been said, certain things have happened, and at this length of time, it is difficult to upset the scene. In as much as if upset, more mischief they would breed than doing justice to others. First, to that extent, the AG is right in telling the court that no benefit of seniority nor of monetary values can be accorded to the petitioner, appointment itself being of 3/8/2018. First, that being said, the minimum benefit of counting his service for all other practical purposes cannot be denied. First, learned counsel for the petitioner is right in pressing into service the decision of Apex Court in Union of India versus Preetilata Nanda 2010 11 SCC 674, wherein paragraphs 21 and 22 read as under. Next paragraph. In the above circumstances, this petition is allowed in part. Semicolon.
Allowed in full, because I have prayed for notional, I have not prayed for area.
Anyway, let's say that way because it should not be taken other way. Which is that order to be quashed?
Annex 9, page 32.
The writ of certiorari issues quashing the impugned order dated
22/7/2020
issued by
the collector.
Issued by OP number
3.
3.
Right.
At annexure 9, a writ of mandamus issues to the said OP.
Yes, sir.
To the said OP to grant notional benefit of notional service to the petitioner sans any monetary or seniority benefits. But so that he shall be deemed to have been regularized in service with the effect from the date
6 years.
Immediate junior figuring in the select list got such regularization.
They have been regularized 16/12/12.
Huh?
16/12/2006 they have appointed. After 6 years they have been regularized. 16/12.
We don't know the date
Yes,
when there, na? It
Yes.
is there.
Yeah, I have given the dates.
You have given the date.
Yes, in the prayer man.
That is 16/12/2012.
Regularization.
12. First, it is again very clear that petitioner shall not be entitled to claim the seniority against anyone, nor any monetary benefits or monetary benefit on the basis of this order. Okay. We have copy to here. No cost, we have copy. Brother, cost needs to be imposed. Why he should suffer? How many years? That too OBC candidate. How many years he should fight? Throughout he has been in the court.
Since we have,
Really,
since,
do not know why.
my lord,
not
since we have implemented your lordship's direction,
No, I
lordship
will
may
when?
liberally, yes.
Cost now. Cost needs to be. Otherwise, this will not happen.
My lord, since 2018, he is continuing in his service. Since your lordship is giving some benefit
Why
from
you
the
pay cost with a cost of 25,000 rupees?
So it is too much, my lord.
Why too much? How many? It is too less actually. Yeah, in Karnataka, we used to impose at least 1 lakh rupees.
In one of my case, my lord, Honorable Chief Justice has granted 1 lakh compensation for this type of litigation, lingering from 92 to.
Otherwise, they will suffer like anything. Cost is not only to compensate him, it is to threaten the bad people in the government. You recover it from the concerned persons. You let it be not paid from the exchequer. You pay it and recover it from those who do not deserve to be there. Get that money from them and enter it in their service register. Everything will be all right. I meant to make that order. I'm just waiting for a good case where I can spoil the service register of some high-level officer. Only then they will do things. Otherwise, they think that all they are slaves. The people of Orissa are slaves of the bureaucracy. No development, no industry, barring few educational institutions. Not even one is a league institution. Not even one.
Your lordship is right.
Therefore, pay 25,000 rupees cost.
10,000 from the hearing officer.
Cost. A cost of rupees 10,000
From the hearing
is
officer.
levy, which shall be paid to the petitioner within 30 days. And if delay is proved, every day 100 shall be added to that. First, the same may be recovered from the hearing officials of the state in accordance with law. Since no cost is levied, they are all doing dancing.
Yes.
Once
I
cost
agree.
is levied, cost jurisprudence we have to develop. Only then accountability begins. Otherwise, they will say government advocate will fight our case. If he wins, very well. If he does not win, it absolutely no issue. Nothing will happen to us. Our seat is
Accountability, yes.
Subhadra. They should be made to pay their. There should be adverse entries in their service register so that they will not get promotion. Where they don't give salary, in some cases I directed that they will not draw their salary till salary is paid to other employees. That is the only way. Sobriety and other things have gone now. The only sword can do the job. Nothing. By pen, nothing is going to happen. Contempt after contempt. You have seen new vistas of contempt law.